Yes.
For delivery of judgment, item 25 and 26.
That's it. In view of the aforesaid discussion, determinations, and reasons, while affirming the conviction recorded by the learned trial court, we deem it appropriate to commute the sentence of death to imprisonment of life. I agree.
Item 27 to 30.
Last question for paragraph. In the opinion of this court, in this context, section 110 must be harmoniously construed with section 92 and section 92, 92, subsection 2(1) of 9 for section 49. The bar of civil court jurisdiction indicates that the legislature intended the dispute to be resolved within the statutory framework itself. If section 92 and 49 are interpreted in a manner so as to exclude such a dispute while simultaneously giving full effect to section 110, the same would result in a self-defeating statutory scheme, one that regulates right but provides no mechanism for their enforcement. Such a construction must be avoided. A purposive reading would then suggest that section 110 reinforces rather than negates the jurisdiction of the registrar. Seen in this light, section 110 aligns with the arguments of the appellant that interpretation adopted by the learned single judge cannot be sustained. If that interpretation prevails, it would not only unduly restrict the scope of section 92 and section 49, but would also render section 110 oppressive in operation of closing the doors of the civil court without opening any effective statutory alternative. Such a consequence would antithetical to the rule of law, which demands that every legal norm must have a forum for redress. For the aforesaid reason, we are of the considered view that interpretation placed by learned single judge on the provisions of the Act 2007 is unduly restrictive. The appeals are accordingly allowed. The judgment dated 13/3/2025 passed in WPC 925 of 2022 is set aside, and the order dated 10/1/2022 passed by the register relating to Bikrampur Cooperative Society is restored. It is needless to say that the respondent shall be at liberty to assail the decision of the register dated 10/1/2022 on merits afresh, if so desired, on which we have made no consideration, as the learned single judge has decided the issue only on the point of jurisdiction without entering into the merits of the claim of the parties. The judgment and order dated 9/5/2025 passed in WPC 6945 of 2024 stands set aside. The Register of Cooperative Societies Assam shall expeditiously decide the appeal and within an outer limit of 1 month from the date of receipt of a certified copy of this order by giving reasonable opportunity of hearing to the parties. This disposes the writ appeals parties to bear their own cost. I agree. Give them, they can have a look.
Adjournment request, if any, from item number 1 to 4. From item number 5 to 15. Adjournment request from item number 5 to 15.
13, 14, 15.
11,
Adjournment slip has been circulated in item numbers 13, 14, and 15.
14, 15, and 16.
1, 13, 14, and 15. वो ऐसे ही लिख देना and give a date.
16 also.
16 also. All 16. He is giving the date.
Yes. 11 June.
सब मैं अलग से date दे देना.
From item number 70 to 24, adjournment request.
Twenty.
21.
20.
Item number 20 or 21? 20. You are mentioning for whom? For the appellant. Okay. Have you informed the other side? As prayed for on behalf of the appellant and agreed to by the land counsel for the respondent. The matter is adjourned to. These are about venture schools, no? The matter is adjourned to so-and-so date. July.
21st July. 21/7.
You have already circulated this. All right, we'll give you a date.
21/7.
May would not be possible. Let's see if May there is any date.
28 May.
28th of May.
28
Doesn't matter. Doesn't matter. We will have it. We'll have the affidavit. We'll hear that matter. It has been heard for a number of days. Let's conclude it. You file the affidavit, you get it at the time. 2 o'clock. All right. Yes. Hmm. Hmm. On account of the learned advocate who is to address this case on behalf of the respondent being not available, a request has been made for adjournment. Have you informed the other side? The counsel for the appellant has been informed about such a motion, such a prayer. Let this matter come up under the appropriate heading on. We will only give you a date in July then.
23rd July.
Yes, Mr. Kyal. Urgent for tomorrow. What has happened? Earlier? Dispose of your? For all you know, 16th of April, they'll decide about the maintainability. They can't outreach the order. They can't disobey the order. No, maintainability is the preliminary issue. They will decide it and then they'll decide on merits. Doesn't matter, no, Mr. Kyal. It is always better if they do that. You can always come and say that this order is a nullity because the precursor part was not done. Let it come after 16th. Huh? 24th. All right. There are many matters which we have heard. So it will come on 21st. Doesn't matter. We will take it as if notice has been issued in that matter. Give your slip. It shall be listed along with those matters on 24th, 21st. Give your slip.
Any other request? No. Daily list for orders, item one.
I want to adjourn it. Oh, item number one, there was an adjournment slip, Mr. Okay. All right, all right. When do you want it? Anytime in May.
May.
All right.
28th May, 20.
AC चलो आ जाएगा हम AC चलो AC yes
Yes, Lord. Item number two.
क्या है
May be Lord, sir.
you're not there on the last occasion.
Last occasion, my Lord, unfortunately, good.
Who appears for the other side so that they can accept notice?
31 days. delay.
Do you accept notice? Would you like to respond? Or you have no objection, then we allow the interlocutory application. 31 days, otherwise also we will allow. So and so accepts notice. This application is for so and so. For the ground stated, the delay is condoned. The revision petition be processed and be listed, preferably on give a date.
For June, 1/4.
Naam likh lena
Oblige.
and show it to brother.
Item number three.
Wait, please, Lord. For substituting the Allahabad Bank with the Indian Bank, my Lord. We were taking steps on the Allahabad Bank was the former respondent, my Lord. It has merged with the Indian Bank, my Lord.
So
So it is
you
no
file
longer-
an application for
Substituting the Allahabad Bank.
substituting Allahabad Bank.
Allahabad Bank.
Not substituting for clarifying. This would require no substitution application. you
Notices
check-
have to be served, my Lord.
Notice will have to be served.
On the
So
Indian Bank.
we allow this application.
Ma'am.
We allow this application and issue notice to the
The Indian
newly added, you provide the memo of parties today in the registry.
My Lord.
2 pages.
My Lord. I'll do that.
The fresh memo of parties shall be furnished by the petitioner. Let notice be issued to the newly added respondent, that is Union Bank,
The Indian Bank, my Lord.
Indian Bank, on steps being taken. Anybody appearing for Indian Bank, if you have idea?
No, my Lord.
So and so steps to be taken within 2 weeks, both modes returnable. Which was the date earlier?
That.
We'll give
order I
a
have
fresh
taken,
date.
my Lord.
All right. The application stands allowed to the extent indicated above.
It was fixed on 22/4, my Lord,
So this will take longer time.
Yes.
Sometimes in May.
in the month of May. I'm obliged.
Memo of parties has to be filed
I'll
today.
file it.
Today or by tomorrow?
By tomorrow will be convenient, my Lord.
25/5.
Paragraph. In paragraph.
25th May.
सुनता ही नहीं।
Item 4.
Puranjit,
Paragraph
इनसे ले लेना।
10 cannot be dismissed.
10 से मतलब नहीं है, you show it to him. इतना दिन का delay नहीं करा।
What's it, delay of 1535 from the date of original judgment in the writ
हाँ,
petition.
भाई,
But from date of, from review lordship, it's about 60 days lordship.
60 days. Well, notice. 2 response numbers?
Many lordship,
Huh?
many, about more than 400 there also.
तो अब क्या करेंगे? You have to notice to so and so on steps being taken by the applicant within a period of 4 weeks, both modes returnable August.
3rd August. Supplementary list, item 31 for orders.
Order. Respondent.
Sole response. This case-
Respond number 5, therefore notice.
This case has come at the instance of the office in order dated 27/3/2026. Inadvertently, instead of notice, direction for issuance of notice to the sole respondent, it was typed as respondent number 5. As such, the notice could not be filed. The order dated 27/3/2026 is modified to the extent that in place of respondent number 5, it should be read as sole respondent. Let fresh notices be issued. Let fresh.
We have taken step that may be sent. to them.
Since the steps have already been taken for issuance of notice to the sole respondent, notice be sent immediately, returnable on. They give the same date.
10/6.
हमने लगवाया है।
Item 32.
How do we file this? I am not seeking.
For the reasons stated in the application, the prayer is allowed. So and so writ petition is permitted to be withdrawn. Dismissed as withdrawn.
Not, I am seeking liberty, my lord, in case for any unforeseen reason.
That's not a problem. You can always come, no?
Lot, deeply applied.
Daily list for admission, item 5.
Ma'am,
Yes,
Your Lordship, in this case, basically, we have already complied with the order.
you have.
Yes, and the principal amount we have paid. So only that the last portion of the judgment, thereby we have been directed to pay the 9% interest on the delayed payment. Basically, we have been directed to pay the amount within 1 month. Thereafter, we have preferred an IA for modification for extension of the time. So only for the interest part we have. paid.
Interest you have not paid.
Yes, Your Lordship.
Interest you have not paid.
Yes, Your Lordship. Only to that extent, Your Lordship. Page number 561, we have complied with the order, Your Lordship. Judgment was passed on 24/7/2023.
Impugned judgment dated 24th, the impugned judgment dated 24th of July 2023. A single judge of this court in WPC number 4884 of 2021. Directed the appellant bank the subsidy amount and close the accounts of the respondents. The order has been complied with, except to the extent of making payments of 9% interest on delayed payment, which is being questioned by the appellant in the present appeal. Let notice be issued to respondents so on steps being taken by the appellant within a period of 2 weeks, both modes returnable July end.
This 7 July.
PD case close हो गया था.
Item 6.
The petitioner, the appellant before Lordship is 100 years old jeweler in Gauhati, Lordship. The case was on a very narrow campus. Also, the file may look very fat. Issue is, Lordship, when certain gold ornaments were sent to Calcutta from Gauhati in the airport, which is a domestic airport at that point of time. The CISF have got hold of those ornaments and found that 1 or 2 ornaments did not carry the challans and the documents.
Yes.
So immediately those were procured and those were given on WhatsApp also. Thereafter, after 3 days, they have seized it, and next day they have passed an order showing that they had reasons to believe. When a seizure is made, Lordship, the reasons to believe has to be first ascertained. Then only they can seize.
But
I am
you
not,
did not, but
I am not on that, Lordship.
Mr.
When this
Rizvi,
proceeding was going
I'm
on.
asking you one question, you
Lordship.
just answer that. There was a show cause notice sometimes in August 2018. After you were restored the jewelry,
Yes,
the case was pending.
yes, pending.
Pending in the sense that then a notice for initiating a confiscation proceeding was
Exactly,
initiated.
Lord.
Notice was dismissed at the motion stage
As a premature,
as premature.
as premature.
So therefore, you must challenge that notice again.
Regarding the
Now, because notice you respond, if they take any decision, you immediately come
No,
before the
the court was in session of the issue that whether seizure was legal or illegal.
question is this.
That issue was
Now,
not
the
decided.
moment the challenge to the notice is quashed, then perhaps it leaves the issue open and the court has a clean slate to decide whether this confiscation proceeding should be initiated.
My humble, that legal issue which I would like to argue in details, that whether seizure proceedings and confiscation proceedings are correlated, or if these are two separate events in the taxation mechanism.
Even then, suppose they are separate events,
Lordship.
but then it is confiscation of the seized amount initially, which seized
But if
jewelry.
the seizure is, suppose in the writ petition, the learned singer found that seizure was illegal, the confiscation proceeding will become redundant.
No. It's that we have laws on that.
I ha-
Seizure procedure, suppose procedure has not been followed, therefore seizure is hit. But they have to take a final call that this seizure was bad. Has it been decided?
That has not been decided by learned single.
So
judge.
therefore
And
that ought to have
learned
been
single
decided.
just said that as because the confiscation proceeding
Therefore,
was allowed to
Mr.
proceed.
Therefore, Mr. Saikia, you would be well advised. Of course, this advice has to be vetted by you. You will be well advised to question that and respond to the notice that well seizure is bad and therefore your notice for confiscating the same is bad. You have to respond to the notice. That's the principle. That's the
principle.
general law which has been laid down in all such cases of customs
I
seizure.
fully agree, Lord, to that point. But the thing is that when we have raised this question before the learned single judge, and which is pending from 2017 till the other day of this.
In this case, to the extent the London single judge ought not to have dismissed your case straight away,
Exactly,
but
Lord.
should have said that you pursue that case in seizure.
If that
And
handle is get-
simultaneously with this, and in fact, you will get an opportunity of presenting
raising
your
that issue
cause,
of seizure also before the confiscation.
presenting your cause. It will be same thing.
That,
Take a
with
call.
that observations, Lord, if it is disposed of, I will be more than happy. Same issue, that point of seizure will.
The respondent shall now fix another date for personal hearing and issue notice on this. 18.3. Just a minute, 252, yeah. Let us come to page 252.
Yes, Lordship. 253, the last line, shortly put, the writ petition is premature at this stage. That
No,
was-
no, not this.
My Lord Justice,
Ordered.
we has order,
Now, please come to the second paragraph at page 252.
yes, may I read it, Lord?
Yes, yeah.
The show cause notice dated 16/8/2018 have required the petitioners to show cause as to why seized gold, garage and bangles concealed amongst the other ornaments valued at 44 lakhs, etc. should not be confiscated. So this is a notice under 124. In exercise of power under 111.
Where are you reading? 252 paragraph, primary challenge to the show cause notice.
Yes, that is regarding the confiscation proceedings. Should not be imposed under section so and so. It is seen that the show cause notice dated 16/8/2000 is detailed one regarding the petitioners to explain in the matter. On going through the materials on record, this court is of the considered view that.
Now come to the last line of the order.
Yes,
Hmm.
put the representative premature at this stage.
Then another line.
In that view of the no consideration of the representative required and the same stands dismissed at the motion stage.
Then there is another line. The
The
respondent shall now.
respondent shall now fix another date for personal hearing and issue notice in this regard to the, so that regarding the confiscation proceedings, that which now they have done after the dismissal of the instant writ proceedings. Now they have issued on 10th of March. And tomorrow the date is fixed for my personal
No,
appearance.
that's all right. So you go there, it shall after you will have an opportunity of questioning the correctness of the seizure itself.
If that observation is given, Lordship.
No, it is understood. No, what do we do? Otherwise, it will be overreaching the executive action
But the
unnecessarily.
thing is that.
If they don't, you immediately come before us. We will put an embargo that unless you decide that that confiscation proceeding comes next. These are not separate events. These are correlated.
Continuation, but once that stage is over, then only we can come to the confiscation. When we have Why they have waited for 6 long or 8 long years
No,
now?
no,
In
that's,
the
that is
constitution-
something for you.
Because the pending is, the case is
Correct.
pending before the learned single judge
Correct.
on the
Because-
issue of seizure.
Caesar, what is the status of that case?
Seizure,
That case has been
that
dismissed.
case has been dismissed because the confiscation.
No, this, we are reading.
I'll place only one paragraph.
No,
Lordship.
18/3/2019 is the order dismissing your challenge to the notice.
Notice of seizure.
Notice of Caesar.
No, yes,
Notice
Lordship.
of confiscation. Caesar
No.
was done.
Seizure was challenged.
No,
That is the difference, Lordship. I'm not being able to
No.
place
Read-
the facts in the right.
No, you have been able to, but we see this at page 252, para 2. This order has been passed. The
This
order.
is not under challenge here now.
Correct. We have followed that.
Yes.
Now, which Caesar, where is the decision with respect to Caesar?
Yes, that is the impugned order. Impugned judgment is that.
Impugned judgment at page?
It starts at page
84.
285. The learned single judge did not enter into the merit of the seizure here.
285.
Yes, it starts here. One paragraph, if Lordship is pleased, may I read it, Lordship, paragraph 2. The petitioner, by way of instituting the present writ petition, has presented the challenge to an order of seizure dated 31/8/2017, issued by the Inspector of Customs, LGBI Airport, Gauhati. The petitioner has also assailed a communication dated 1/9/2017 by which reasons to believe that the goods seized by the order dated 31/8/2017 were
Correct.
illegally
Then
imported
what
into
happened?
India
Hmm.
through a route other than those specified under section 71C of the Customs Act and the violation of other provisions of the Customs Act was communicated. It was further communicated that the goods so seized were now mandated to be
Yes,
confiscated.
so
under-
therefore you should argue this. Now come to paragraph 5, then it becomes
Yes, the paragraph.
lose-lose situation. You don't, the judge does not enter into the maintainability of proceeding, saying that
Lordship,
there
can
has
we
been
come
a
to 4.3. The court having not restrained the custom authorities from further proceeding with the matter, the custom authorities after seizure so made issued a so-called notice that is after 1 year, 16/8/2018 by invoking the provisions of 124. This is a separate proceedings. The said so-called
No,
notice
no,
was so issued.
separate, please keep yourself aside this submission of separate notice. These are interconnected.
I
These are
understand,
part of the
at
same.
different stages.
You will get another flashpoint. You will get another, point where you can challenge. Now look at this. 4.3 is all right. The said show cause notice was so issued requiring the
Now
petitioner to
5,
show cause.
paragraph 5.
Yes, that is what I
In
want you
view
to
of
read.
the said development, taking issue in this matter, the issue arises as to whether present writ petition would be maintainable after the issuance of the so-called notice dated 16/8/2018, initiating confiscation proceedings in the matter against the petitioner company. As agreed by the learned counsel for the parties, the said issue is taken as a preliminary issue for consideration and basing on the
Now,
decisions
now,
thereof.
with respect to this, where is the discussion in the
Yes,
judgment?
that discussion is now, the findings, Lordship will see paragraph 9 onwards, but main issue at paragraph 13. The court has perused the record of WPC 1788, that confiscation proceeding was challenged in a different proceeding,
Hmm.
and finds therein that the petitioner had duly disclosed
Paragraph, which?
13, page 294.
Hmm.
This court has perused the records of WPC 1788 and
And
finds
this WPC 1788 was?
that my Lord Justice Bhuya's order, that
Okay.
premature dismissal,
So both the petitions they dismissed.
and finds therein that the petitioner had duly disclosed about the fact of pendency of the present proceedings as well as the nature of challenge raised in the present proceedings.
Hmm.
The coordinate bench of this court, while passing the order on 18/3/2019,
Hmm.
had accordingly passed the same by also noticing the nature of challenge presented in the present proceedings. The coordinate bench of this court, while order dated 18/3/2019, having recorded a conclusion to the effect that the so-called notice dated 16/8/2018 to suffer from no jurisdictional and/or legal defects shortcomings.
Now,
The
Mr.
state-
Kyal, now look at this. You don't enter into merits of the Caesar. I mean, we are talking about the single judge's judgment. You don't enter into it for the reason that a so-called notice has been issued.
Yes.
And you don't entertain the petition against so-called notice for lack of any jurisdictional error. So it's a win-win situation for you and lose-lose situation for him. Can this be done?
Let's see what happened.
No, either at one place you have to hear him, no? See, he wants to preempt this proceeding. He has challenged he has challenged the very seizure.
Yes, sir.
Now, if the seizure is challenged, the court here, and this is the judgment, in this, the writ petition which was preferred earlier, WPC number 6204 of 2017.
Okay.
This should have been heard since the fact that a notice has been issued. Notice, it will be seen later. Notice he will respond. But then this issue was, it had to be decided first, no? See, what you do is this. Simply put, he challenges the seizure. He says that I am an old jeweler.
Correct.
One of my employees was carrying it for polishing, for cut work or whatever. We have the delivery challans or whichever permission challans. One of it was missing, which was available on the WhatsApp.
Yes.
Nonetheless, the customs thought that it was imported into India from a different source, unexplained source. Therefore, they seized it. Seizure, all right. You were asked by the court to deliver it. In the interregnum, it was delivered also. Correct. So he challenged the seizure on principle, but with the return, the case never ended.
Yes, sir.
So this seizure, if this seizure is questioned and the court does not look into it on the ground that a notice already has been issued, could the notice have been dismissed on that ground that seizure, because the seizure is dependent with the notice?
No, Lordship.
You can't shut a person against the wall so that he doesn't have breathing space.
No, Lordship.
ये तो नहीं है ना.
Under section notice.
Where is the difficulty? You decide. This should have been decided.
He's here, Lordship. We are very open, Lordship. Let them.
You are very open, so give them time.
Yes, Lordship.
They will respond to the notice, and you first deal with that. How would you say? How would he respond unless he is given that leeway to question the very seizure?
Please come to page 296.
Yes.
That opportunity was given to them when after it was issued on 10th of March 2026 after passing by the passing of the judgment of the Leonard single judge. In this connection, I am directed to inform you that fourth paragraph, as per the CBSE circulation, they have given sufficient time.
No, that's all right. Now you give them. They did not respond.
No, no, they didn't.
Pursuant to this notice, they did not respond.
No,
Why, Mr. Saikia?
Lordship. Regarding
Pursuant to
that,
this notice,
which notice, Lordship?
at page 296.
96. We appeared, Lordship, and we sought time because an appeal has been preferred. And they again issued another notice on 26. Tomorrow is the date for appearance. We are not running away.
No, you decide this first.
yes, Lordship, let them,
Now, the Lordship, one thing is very clear. I would like to raise this issue before this honorable court. One point is seizure. The other point is confiscation. If the seizure is bad, because the seizure has been done by the same authority.
Is that not the, Mr. Saikia, we are not very impressed by this argument for the reason that with the issuance of a notice for confiscation,
Lordship.
the only ground that you can raise is that the seizure is bad. So therefore, you get a platform to voice your grievance that the seizure is bad, necessary materials, necessary documents were not perused, and therefore it was wrongly seized. And you have balance of convenience in your favor because the court initially found that the seizure was bad. They asked them to return it in the interregnum.
That was a
So
pri-
you
was
say
a
that
prima
I am a
facie
jeweler.
discuss- That is not a final findings. They will come with the opinion.
Correct.
That
Correct.
this
So-
was a prima facie opinion
Correct.
of the
So I
learned single
think
judge.
the best course for you is to go before the authorities. Of course, they will
I
give-
have no difficulty in
they
going.
will go before you. Now, in this proceeding only, don't maintain 5 different proceedings at 5 different places. This is the proceeding where you can question the very correctness of the seizure and say that if the seizure is bad, what confiscation? This is the notice. Suppose a vehicle is
I
suppose under
understand.
the
I fully understand.
under the public distribution system, or for that matter under the Forest Act, suppose a vehicle is seized.
Earlier that 351 CRPC.
A vehicle is seized. Now, one application is filed under 452, old 452 or 457 for release. But there is a provision in all forest acts, all state forest acts of confiscation. Now, in that confiscation only, matters are decided. And normally writ petitions are not entertained. That is a full bench judgment by Patna High Court, affirmed by Supreme Court, authored by me, which says that once the confiscation proceeding is set afoot, no interference. So
with that
therefore,
whatever that observation Lordship had taken in that judgment, give kindly.
we are not
No,
conflating.
only issue is that Lordship, if Lordship gives an observation, that I can raise the issue of the validity
Why
of the
not?
seizure in the confiscation proceeding, I will be more than happy.
We will do it.
Then I have no difficulty, because I will raise the same issue before them. Whatever I will have argued
We
for
are,
the learned.
we are not
judge,
going to, Mr. Saikia, we are not going to circumscribe the power of the state, the power of the
Lordship,
state authorities. What
that
we will
is
say,
the Lordship will
it is
give us-
expected that he will question in this notice only, because that has not been responded. Before it could be responded, you have issued notice, you have slapped a notice. See, we do not permit either of the parties to strangulate and choke the other.
We do not want that.
No,
We
no,
want a
I'm-
fair hearing and
we-
fair decision. That decision may be
I'm
taken to
not,
the
on,
learned.
I'm
single
not
judge
on your action, I'm on the action of the state. Unfortunately, you're not for the state now.
for a change.
You always, for a change, you always argue for the state, and you would have seen that this is our approach. The state with all its might cannot choke you to death. You must have a breathing space. So that they will not do. You have challenged it. Both petitions have been dismissed. In this appeal, we say that in the notice, you will also question the correctness of the seizure, because that has
That
been.
will give me the handle, Lordship. I want somebody to hear me. Either the learned single judge, because my prayer would have been,
Correct. You
it will
have
be
no
remanded
problem.
back to the learned single
Mr.
judge.
Kayal, that is very,
Yes, yes, sir.
that's the minimum demand of a person
Lordship,
who is in this trade for a very long time. So to that extent, we dispose of this appeal by saying,
Yes,
Lordship.
without dismissing, dispose of with an observation that,
we will do that. We'll do that. Chaliye, likhiye.
because the interpretation outside goes different way, Lordship. That's why, because why I am saying, the learned single
After all,
judge did not tell me.
why Mr. Saikia and why Mr. Kayal are there?
So,
Proper,
the
correct
problem
interpretation.
is
correct
somewhere
interpretation.
else, Lordship. I will not make any comments. The thing is that, Lordship, the learned single judge did not enter into the
But
merit
I'm
of the
happy to
case.
see that after representing the might of the state for a long time, you also get an opportunity of
No, no,
for
I
a
am
weaker
regularly
party.
appearing for
Of
customs
course,
cases.
stronger in his own rights, but a weaker party in front of Mr.
No,
Kayal.
Lordship, the other day there was an objection that I cannot appear for the
No,
private.
I don't raise
That there's a judgment of this High Court, so I can appear.
that objection. We don't raise. We don't raise ever.
it was
It is
raised-
upon the
it was raised
ethical
by same
standard
counsel.
of the lawyer. This court has never questioned.
A GST matter, and the
Yes.
court gave a very favorable order
Yes,
in my
Lordship.
favor.
This is central government. You are from
Exactly,
state-
Lordship. This is, oh,
It's a common sense. We
still they object
No.
on writings, on affidavit.
No. So you don't represent central government.
I don't represent.
No,
I'm
object-
not paid by them.
that
I'm
object-
not taken,
that
I'm not
objection-
getting a brief from
that
them, and why I
objection-
cannot appear.
See, that objection is illusory. That doesn't mean
But
anything.
on affidavit, they keep objecting.
relating to GST matter. State GST and central GST.
Then they,
Central government has a separate set of counsel.
okay.
Mr. RKT Chaudhary cannot appear in his place.
State case, so that matter are relating to CGST.
Sure. Are you questioning his?
This case I am not questioning. Because before-
When it was question answered in my favor, Lordship, and they are happy with that, they did not go to the Supreme
Yes,
Court.
Lordship, before- also.
We are disposing of with that direction. He has the liberty to question that, which he can, and you will decide it.
Section.
We have heard Mr. Debajit Saikia, learned senior advocate for the appellant, and Mr. S.C. Kyal for the respondent customs department, for the respondent / customs department. This writ appeal filed by the appellants who are well-established family-run jewelry company who have been operating for several years and are registered under the GST and other tax laws. In the year 2017, while an employee of the company was flying domestically from Gauhati to Kolkata, he was purportedly intercepted on the ground of carrying old gold and diamond studded jewelry, which was claimed to be belonging to the customers of the company. The purpose of the transport was repair, polishing and cutting work. The employee in question was having in his possession delivery challans and other documents, which apparently did not exactly match with the demands of papers asked by the customs department. The employee was detained the entire consignment of jewelry was seized under the Customs Act. According to the appellants, the seizure was bad as there was no evidence of the jewelry not being domestic or an used item which had never been imported or was not and was not to be exported. The seizure also was questioned on the ground of having been made beyond the custom area. The records reveal, next paragraph, the records reveal that this seizure was challenged by the appellant by writ petition number by WPC number 6204 of 2017, wherein the order of release of jewelry on furnishing security was passed. The jewelry, the seized jewelry was returned to the appellant on furnishing a security of rupees 11,17,530 against the valuation of the jewelry at 44,70,121. The writ petition was pending. In the meantime, the respondent/custom department issued a show cause notice to the appellant confiscation of the aforenoted goods. This notice was separately challenged. This notice issued on when the notice?
2019.
18/3/2019.
No.
No.
The confiscation, 31?
Confiscation, yes, Lordship, 18/3/2019.
No. That's in
Sorry.
August, no?
Yes, it was in 2007.
31/8/2017.
16/8.
18.
16/8.
16/8/2018, page 230.
This notice dated 16/8/2018. What did I say? भूल गया. What? 2018. Date गलत मत लिखना फिर confusion होना है. 16/8/2018 was questioned by the appellant इसके पहले हमने क्या लिखा था? Writ petition was filed. Read the first the paragraph which. Show cause notice dated 16/8/2018. हाँ, तो उसके बाद पढ़ो क्या है? This अब नहीं लिखना है. This notice was questioned by the appellant in WPC number 1788 of 2019. On the grounds of limitation as also on jurisdiction. But as also on jurisdiction. However, the writ petition was dismissed by order dated 18/3/2019 on the ground that there was no jurisdictional or legal defect in the show cause notice. This order was passed at the motion stage a direction to the respondents to fix another date for a personal hearing of the appellants after issuing notice in that regard to them. This court has been informed today that the next date for the appellants to appear pursuant to the notice is tomorrow, that is on 8/4/2026. They, Mr. Saikel and senior advocate drew the attention for the appellant, drew the attention of this court. वो वाला पेज कहाँ है? Mayer का. क्या लिखा है bro? नहीं ऐसे वो कर दो. Mr. So-and-so, learned senior advocate for the appellant, submitted that the writ petition number, that WPC number 6204 of 2017 was primarily dismissed. Challenging the seizure was primarily dismissed on the ground that with a coordinate bench not interfering with the issuance of notice proposing confiscation, the seizure could not be challenged. Seizure could not be challenged. While dismissing the writ petition, learned single judge in this instance observed that with the dismissal of the writ petition challenging the issuance of notice for confiscation, which order has not been assailed by the appellant, with the result of such notice having been having attained with such order having attained finality, which is a precursor proceeding of seizure assailed in the present writ petition, bracket में 620 जो भी number लिखा है 6, I keep forgetting the number ना 6204 of so and so. Mandate any consideration on merits. the appellants submit that this is a situation where there appears to be a confusion. This is a situation where it could not be decided by the authorities whether the cart is before the horse or the horse is before the cart. Reading of the judgment impugned in the present appeal reflects the opinion of the learned single judge dismissing the challenge to seizure, that the appellant shall have an opportunity of questioning the seizure too in the proceeding initiated and show cause notice issued to the appellants proposing confiscation of the goods. Without that, we are of the view that the appellants would be choked. Appellants would stand strangulated without any passage for them to explain that the seizure was bad. Considering the observation of the learned single judge dismissing learned single judge in the impugned order, that proceeding to initiate confiscation of seized goods strike that off. We'll recouch it. The observations of the learned single judge in the impugned judgment clearly reflects that no consideration was made with respect to seizure. No consideration was made with respect to the correctness of the seizure. Ground that the appellant has already been noticed proposed confiscation, which is a precursor proceeding of seizure, which is not a precursor. गलत लिख दिया है, precursor नहीं है. Read that again. Against the proposed confiscation, which in our opinion is only a subsequent proceeding. Subsequent proceeding. Since the arguments raised on behalf of the appellant against the seizure was not entertained by the learned single judge, in all fitness of things, we are of the view that while responding to the notice for confiscation, the appellants would be entitled to question the very seizure of old used ornaments belonging to the customers of the appellant. We thus dispose of this appeal with an observation that since the issue regarding correctness of the seizure proceedings were not entertained by the learned single judge in WPC number so and so on the sole ground of the challenge to the issuance of notice having failed in the first instance, comma, the appellant shall be given an opportunity of explaining their cause. That is, to question the seizure and then to question the seizure, to question the correctness of seizure, and ultimately the decision to confiscate the same. With the aforenoted observation, the appeal stands disposed of. I think this is good enough.
Lordship, I am deeply obliged, only that tomorrow is the date for my appearance, it's little bit of extension maybe.
It further, since, as I go, to provide reasonable opportunity to the appellant to present his cause, it is expected that if a request is made before the authorities for extension of date for the appellants to appear in the confiscation proceeding matter, comma, the same shall be granted.
Highly obliged, Lord.
Appear and file, appear mana file.
Deeply obliged, Lord.
Yes, sir.
Item 7.
Wait, please, Your Lordship. May I pray that the matter may be taken up after some time, my lord? Learned additional AG is on his way, my lord.
What is this matter about?
My lord, IMFL own license was issued, my lord, that under the old act, my lord. Now, they have, my lord, amended the excess rule, my lord, and under the excess rule,
Yes, sorry.
under the excess rule, my lord, by the amendment, they has introduced one, my lord, duties, base price above and above all other price. Meaning thereby, my lord, 10 lakhs has been fixed for direct settlement of the, my lord, IMFL on, or issuing the IMFL.
What
on
did we
license.
say on the last occasion?
Yes, my lord, lordship has, my lord, observed the entire matter of the petitioner, my lord. 13/2/2026.
No, no, we have said that till such time, the petitioner to begin his operations may deposit 10 lakhs under protest.
My lord.
That shall be returned to you. So he is not there. Have you filed your,
Response.
have you filed your response?
Not yet, my lord.
Why?
We are seeking some time.
Why then we will ask them to be, then we will allow that prayer. That in the meantime, he may be allowed to start his operations.
My lord.
You will recover 10 lakhs later. Why don't you reply?
We'll immediately file it, my lord.
When will you file it?
On reopening, my lord, we immediately will.
On reopening.
Yes,
Take care. What is your name?
I bought.
Mr. I. Thakur, learned advocate, on behalf of Mr. P.N. Goswami, learned additional advocate general, Assam, submits that the response affidavit as desired by this court has not yet been filed, but shall surely be filed on or before the next date. Re-notify on April, re-notify on 29th of April.
Obliged.
Item 8.
Here, we are against the interim order, my lord, this.
Huh?
Because the interim order, the care, my lord, is. Peace immediate, my lord. Yeah, my lord, this,
It is coming for the first time. I think.
promotion, my lord, will be decided.
Let us see the order.
In, last order, the interim order, my lord. 217, my lord.
Interim order, hai?
Yes, my lord. My lord, he was promoted, my lord, he was, my lord, and posted in Kolkata, Shillong, my lord. And he is, my lord, prayer, my lord, he was, my lord, to posted at Kolkata, my lord, the compensate ground, my lord.
And what is the next date?
Yesterday was the date, Lord.
Yes.
Huh?
Yesterday was the fifth date for filing WS. They have not yet filed WS.
You
No,
would not have filed, but then where is the question of staying this order of transfer?
and no
Let the proceeding be completed. In the meantime, you join. And
the
then
application has been preferred by them for vacation of the order also, Lord.
they have filed an application.
Not for vacation of the, they have not filed.
No,
application.
have they filed an application for vacating
No,
the
no,
stay?
no, not yet.
Why don't you file that? If you don't do, therefore, suppose here you are standing as a respondent.
Yes,
And if you don't file your response, what will I do?
yes, my lord. But.
You file an application for,
But our plea was, my lord.
you file your written response and also file an application for vacating this stay.
My lord, contempt is pending, my lord, one contempt stay.
Contempt, we will see. Contempt is pending before this court.
No, my
Contempt-
lord, in before the
Ah,
case.
so we will say that you will do it.
Contempt, my lord, no observation may be given.
They have not complied, Lordship, and the stay will be ineffective, Lordship. The order.
We are desirous of making it ineffective here and now. This transfer order could not have been stayed.
No, Lordship,
Whatever.
Promotion.
there is a provision in the transfer policy, Lordship. Two of his children, minor children, both are disabled.
Sorry,
Both are disabled.
that's something else. But then not on principle. You can't claim it as a matter of right.
No, Lordship, and Lordship will have their ground, Lordship. They say that they are not against our.
We are
proceeding in the court at all.
leaving it for the present. We are disposing it off with the concession with Mr. Medi. Mr. Medi shall file his written response in that petition and shall also, if so desired, file an application for vacating the stay. Correct?
Yes, my lord. So for contempt is, my lord, that observation may be given.
The contempt shall be decided, we will do that.
Lordship, a time frame for contempt.
That's your, it's your doing, Mr. Medi.
Yes.
Why should we help you to litigant like you?
छोड़ दें, dismiss कर दें.
Dismiss ही कर
We
दो.
can dismiss this petition on the ground that you have not filed any WS.
No
And
vacancy.
instead of filing an application for vacating the stay, you have come straight away.
Contempt.
Because the courts, you know,
But our place, my lord, there's immediately he joined, my lord, there's provision. then-
Where is your plea? Where have you filed this plea? In High Court?
My lord, in written statement, my lord.
You have not filed a written
written-
statement.
you have not
No,
filed
filed
a
a
written
written
statement.
Initially, they have done, there is, there is a OA, my lord.
Like you people have earned this kind of a stay order. He has not earned it, you have earned it.
Yes, my lord, the lordship may dispose of.
तो चलिए इसको dismiss कर देते हैं.
Dispose of, my lord, and.
Dispose of नहीं, dismiss करते हैं.
My lord, so for contempt is only the observation may be given, because the.
You are only trying to have a cover for the contempt petition.
My lord, we immediately, my lord, we.
And
filed
say
it
so.
After order.
So we will direct that your written statement shall be accepted and they'll also file an application.
इसको भी नोटिस नहीं दिया ऐसा लगता है कि सब ये they will not file for months.
Mr. Mary, learned CGC, has questioned an interim order of the Central Administrative Tribunal dated 24/10/2025, passed in so-and-so, whereby the transfer of the respondent to Shillong,
My lord, promotion, my lord.
the promotion and transfer of the respondent to Shillong, whereby the promotion of the respondent to the higher post and his transfer to Shillong has been stayed. The respondent is a government engineer who had joined service in the year 2013 as a junior engineer in the military engineering services. In March 2015, he was promoted to the higher post of assistant engineer and posted to Shillong in the state of Meghalaya. The promotion and posting both were challenged by the respondent before the tribunal at Gauhati. the tribunal directed the respondent department, directed the department to reconsider the case of the respondent and pass a fresh speaking order The speaking order, no doubt, was passed on 17th of October 2025. Rejecting the contentions of the respondent, but also letting him know that as per the official cadre management policy of 2015, the respondent could apply for transfer to a preferred place on personal grounds, but only after he physically serves at the new station for at least 6 months. Stop. On the same date of passing the order, a fresh movement order was issued by the appellant department directing the respondent to report to Shillong. This was again challenged by the respondent by OA number 308 of 2025. The contention of Mr. Medi that within a week of the filing of OA number 308 of 2025, the tribunal passed the impugned interim order, putting on hold both the promotion and posting order of 7th of March 2025, along with the movement order of 17th of October 2025. The grievance of the petitioner / Union of India / the department is that no reasons have been accorded for grant of stay. Mr. Dr. G.J. Sharma, learned advocate for your PhD. In which subject?
In law, my lordship.
Mr. Dr. G.J. Sharma, learned advocate for the respondent, however, submits that up till now, no WS has been filed by the department in the earlier writ proceeding, in the earlier OA, in the pending writ petition, in the pending OA, nor any application has been filed by the department for vacating the stay order. Stop. The present petition has only been filed by the department to obtain a cover for them against a contempt notice issued to them. Against a contempt application pending before the tribunal. Contempt application pending before the tribunal. Without giving any opinion over the merits of the matter, we accede to the submissions of Mr. Medi for the department that within a week, written statement shall be filed before the tribunal along with an application for vacating the stay of the promotion, posting and transfer order of the respondent. Stop. What have I said? And in that case, the tribunal shall look into it and pass a final order, or shall decide the application for vacating the stay in the first instance. in the first instance. But before initiating any contempt proceedings, with the aforenoted request, the appeal stands disposed of. Request to the tribunal, the appeal stands disposed of. Maximum.
10 days below instead of 7 days.
Huh?
Instead of 7 days, 10 days below.
Within 2 weeks. अभी तो dismiss करते हैं हम इसी ground पे. Because we are not happy with that order.
Yes.
I mean, transfer cannot be so easily questioned.
But for your
Highly.
Item 9.
May I please, Your Lord?
Yes.
This matter pertains to a brick lane.
It's always the expression is may it please, not may I please. Why should you please the bench? You are respectable in your own rights. Why would you please the bench? The matter should please the bench. So therefore the expression is normally this happens, but I thought I must tell you. May it pleases your lordships. That is the correct expression.
I'm
Correct?
authorized.
All right. Yes.
Doesn't matter. This is regarding a brick lane at a village in Jamla, Islampur, in Kamrup rural district, Your Lordship. What has happened is that, Your Lordship, this brick lane has been, there's been a lot of pollution which is going, which is affecting the village, Your Lordship. the
How
concerned
about
village.
construction work? Have they taken all necessary environmental clearance?
Lordship, that
They
is-
have to.
That is the,
What is your report? Did you ask the pollution control board?
Lordship, we have filed complaint. Lordship will kindly find. at
What has
page-
happened to that?
Page 36, we first initially filed a complaint with the DC, Your Lordship, Deputy Commissioner,
DC has
He's-
so many
he's
other
the-
works you will not do.
Chairperson of District Environment.
State of Assam, district commissioner, circle officer, they are irrelevant. Yes.
Then we also filed with Pollution
Really,
Control Board also. Your
Chief Inspector factories, no, factories में आएगा नहीं. एक मिनट, pollution control board को party बनाया कि नहीं?
Page 50.
Mr. Barua, you are appearing for response number 1, 2, 3. You are appearing for 4 and 5. Mr. Barua, पूरा नाम क्या है? And 1, 2, 3 and 6. Where have you implemented the pollution control board?
This is, sir,
Pollution Control Board, Your Lordship.
4 and 5.
We have submitted, Your Lordship. We have submitted application.
Impact assessment. है.
Page
Pollution
40.
control board कौन है?
Corresponding member secretary.
अच्छा, member secretary pollution control board.
Member
Yes.
Secretary, Your Lordship.
Will not issue notice to respond
No,
number
no.
7.
Not now.
We are not issuing notice to respond number
Later.
7. You have to respond. He's running his brick kiln. I don't know whether he has his clearances in place. Take down. You respond after taking all instructions.
Today morning, when I was consulting with the officials of the board, I have been told that they already consent to establish and the operation is on. Once the operation is on, and this has expired in.
Writing will dismiss his petition.
That's what-
Lordship, there is one more aspect that.
But then why did they not consider that it is going to create all these problems? And it should have been located away from the, housing and other
Yes,
places.
yes.
It's just by the side of the river. That also, I think, have you taken it into consideration?
So they said-
All the ash and everything would go in the river. But all brick kilns are by the side of the river because they have to extract
Sand.
sand mixed mud. Anyway, file your
And
response.
your Lordship, sand requires your environmental clearance, Your Lordship, for
Yeah.
digging.
They
sand.
let them respond.
Lord-
The president of the Islampur Gaon Samiti who represents around 400 families of the village has objected to this, has objected to the continued operation of a brick kiln run by respondent number 7, which was set up in the year 2025, a place which is very close to the village. Located near Kulshi River, which is ecologically sensitive as it is home to endangered river dolphins, which are protected under the Wildlife Protection Act 1972. the grievance of the petitioner is that the brick kiln in question has been established without, has been set up without any public consultation, or mandatory environmental clearances or permissions required under the law. The concern of the petitioner is that the brick kiln, the running of the brick kiln results in large amounts of smoke, dust, ash, and harmful gases being released in the atmosphere. Apart from water pollution. The spiral effect of damage to crops. I don't know how. How do you say damage to crops?
Lordship.
Damage to crops and soil in the nearby paddy fields has also been cited. Stop. Notice to response number 1, 2, 3, and 6 is accepted by Sumitra Sharma, Government Advocate Assam, and Mr. Mr. S. Barua, Learned Advocate, has accepted notice on behalf of response number 4 and 5. Let the response affidavit on behalf of the respondents be filed by the next date. Re-notify June.
Deeply open.
June. Item 10,
Insurance for the deposit open. So accordingly, our registered general to be a party. The moment registered general is not a party, no, this is gone. You can see order dated 12.
Response happened does. It should have gone before the single judge, but then with the implement of Registrar General, it has come before
Yes,
the judge. You respond. Respond to the issue raised by the single judge now.
That is not the issue. Issue is whether this interest is paid to the claimant, which are kept in the account of Registrar General.
It should not have been. He should have questioned that. In fact, whenever we ask money to be deposited in the High Court, we say that let it be invested in a short-term deposit, interest-bearing deposit, and with the interest it is returned. Who kept that interest? Was it kept in some interest-bearing scheme? High Court has to explain this, no? Normally we should be careful in passing this order. If we are asking for deposit, then we must ensure that it is kept. It is not parked idle. No, but it would have earned only minimum interest if no FD or something was directed for. But registrar would not have done it of his own without the order of this court.
If you also kindly come to the order passed by the member MSCT, page 241, it has been written. Last 3 paragraphs. It said this, the member MSCT derived conclusion that this 2 lakhs rupees was a statutory deposit instead. It was not towards the claim.
Not for that. You come to order dated 12/8. On a submission by Mr. Goswami, what generally happens, that's why Registrar General was directed to the party.
Yes.
And accordingly it is listed. So
What
respond to that.
What happened to that 2 lakhs rupees? Yes,
Not 2 lakhs,
Not to like in general.
in general.
normally.
Ah,
What we do, Muller, with
What
the
we do?
deposit. I'll get the instructions.
that is that.
I'll get the instructions. And file an affidavit. Muller.
डिक्रिटल अमाउंट का क्वेश्चन नहीं है, वो इंटरेस्ट उसके साथ जाएगा कि नहीं, अल्टीमेटली
कुछ नहीं।
तब भी है। इंश्योरेंस कंपनी वो भी चार्ज की, वो भी कहा है कि नो इंटरेस्ट टू चार्ज मनी दैट वाज डिपॉजिटेड प्लस ट्राइब्यूनल इंटरेस्ट ऑन नो फॉल्ट लायबिलिटी आल्सो. So it is not only that. Question. Are you questioning the interest? Are you questioning the direction of giving you interest? Just a minute. Interest on
Interest on the
no fault
deposits.
liability also are you questioning?
Not question.
Forget about 2
Whatever
lakhs.
returns is made by the registry lordship after disposal of a MEC appeal. Sometimes there are even bigger amounts are there because we deposit higher amounts against stay orders. And usually the statutory deposit 25,000. Other high court lordship, like this, I know
Mr.
Calcutta,
Das, you
Mumbai,
respond.
they return it with interest.
Mr. HK, well, let me explain. Otherwise, your affidavit will go here and there. I mean, let us.
Understood your lordship's point, my lord. I will also write in that.
Let us
Let us give let us give an introductory background to this case, unnecessarily before the division bench. The single judge could have done it by seeking without him pleading the registrar general. Road accident occurred sometimes in the year 2002, where the son of respondent number 1 had died. The Motor Accidents Claims Tribunal passed an award sometimes in the year 2005, directing the insurance company, directing the appellant / insurance company to pay an amount of 4,39,700 as total compensation for the death. This award was challenged by the appellant before this court by WPC number 7008 of 2005. During the pendency of the aforenoted writ petition, the appellant had deposited rupees 2 lakhs in the High Court through check 16th of November 2005. But ultimately, the writ petition was dismissed. Writ petition by the appellant was dismissed. The matter traveled to Supreme Court. Dismissal order by this court was set aside and the issue was remanded for a fresh consideration. However, the challenge to the award was ultimately made by the appellant / insurance company by way of a regular statutory appeal under section 173 of the Motor Vehicles Act. The focus of the challenge was the quantum of compensation. The appeal was dismissed, restoring the original MSCT award of rupees 4,39,700. The award, the quantum of the award amount was paid by the insurance company, by the appellant / insurance company. which included the earlier deposit 2 lakhs rupees via check, through a check. The High Court. Stop. The interest on that amount, however, was not paid. Stop. It is not known whether the amount which had been deposited by the appellant in the High Court was put to any interest bearing deposit scheme and whether it earned any interest. Stop. In any view of the matter, with the pleadment of the Registrar General of the High Court, the matter has come before the division bench, with this division bench. Stop. Mr. H.K. Das, learned advocate who represents the High Court, shall take instructions in the matter and shall file an affidavit on the issue whether the deposit in the High Court was put to any was invested in any interest bearing scheme, and also as to the procedure adopted by the High Court in case of no such direction by a writ court asking the insurance company to deposit the amount even under protest in the High Court. What did I say? In any interest bearing scheme. And also regarding the procedure, adopted by the High Court. In the High Court. The affidavit in question.
Question of larger interest in all statutory deposits, which is returned, that interest, that's my point.
We are not concerned with that now. Whatever interest was earned on that amount because of the delayed payment, that must go to the beneficiary.
Yes.
That is out of question. Can you argue that?
No, no, so
If you
my-
can't argue that,
and
then don't raise that plea. If you say that, we straight away reject it. Number two, you can only argue on a limited point of the direction of the High Court or of the direction of the MSCT to pay interest on the default liability of 50,000. That is a question which you can raise, otherwise not. Correct? For delayed payment interest has to be given.
Just raising one.
Anyway, let the affidavit come.
Lordship, when the statutory deposit refunds are
But
made,
we are not
should
ending
it
the
carry
matter.
interest, Lordship? That was my point, Lordship.
Whether any?
When the statutory deposits are refunded, Lordship.
This was
get it
not
without,
statu-
we get it without interest.
Mr.
Lordship.
Mr. Goswami,
Yes.
you are talking about interest of 25,000 rupees. I'm
Yes.
sorry, that is not the issue here.
But I thought.
Statutory deposit is 25,000 rupees. Are we questioning that?
No,
Has he
and
questioned that? I mean, has
it can
the,
also be, Lordship, at the same time.
we are questioning the correctness of the order where money was deposited in the High Court and there was no direction for investing it in an interest bearing deposit.
In the facts of
But
this case.
whatever interest it has gained, that must go to the beneficiary. Can you question that? Is that a statutory
No,
deposit?
Lordship, I have paid the amount in this case.
Huh?
We have already paid the amount, Lordship.
What he's saying is that, this 2 lakh was a statutory deposit.
No. That is what I am telling him. It's not a statutory deposit. Okay, is that a statutory
No,
deposit?
what
that's
he's,
not
I could understand, what he's proposing is that whether the return of the statutory deposit shall also carry interest.
No,
That is the
no,
relevant.
It's not a question which has been raised. Why are you arguing it? Are you talking about default liability interest?
No.
And then this 2 lakhs rupees this was under protest that, I mean, for keeping the petition alive, it was deposited. In fact, it should not have been deposited without the stipulation. Let's see.
June.
We'll come back in 5 minutes. Yes.
Item 11.
Your lordship. The last occasion, your lordship directed the respondent
Barkan Das,
file an affidavit.
let this matter. Let this matter be listed for, this is admitted for hearing. Let this matter be listed for hearing on. अभी जुलाई में कब लगा?
10 July.
We'll hear you.
Item 33, supplementary list.
Item? Yeah, yeah.
Yes, sir.
Yes.
Final voter list is on page 45, my lord.
This is where I will authorization.
Our name is included to the final voter list, my lord, after special revision, my lord. All procedure was followed, my lord, and published this final voter list, my lord. And we are included in this list, my lord, and after
This judgment was passed when?
judgment was, my lord, page 73, my lord.
31st March.
2/4/2026.
My lord. Okay.
You were given 15 days
Yes, my lord.
and you did not
15 days
file
given
any petition.
After completion of the election, my lord.
That's all right, but
And,
you should have filed the application.
If, my lord, our name is deleted from the voter list, my lord, our name is not deleted from
On
the
your
voter
asking,
list,
we will not do, no. Unnecessarily, it becomes infructuous.
my lord.
Because we will not pass any order. You should have followed the order directions issued in
Yes,
paragraph
sir.
20 of the impugned judgment. Do you
Sir,
think we will
Lordship.
accept your submissions?
That's it, section 23 will come if our name is deleted from the voter list, my lord.
They say that it was never added. They say it is never added. Their names were deleted because your address was not to be found. You had shifted to another address.
No, my lord, we are not shifted, my lord.
I mean, who will decide?
Can they say, my lord?
Question is,
If I
question
shift,
is, can
I
this
shifted, my lord, there is a
अब
requirement
सुनिएगा एक
of,
मिनट बात तब ना कितना भी no matter how much of excitement you may show, we are not going to accept one affidavit against the other affidavit.
Lordship,
Are we?
there-
If
there
you want
must-
that, if you want that to be decided, सुनो तो सही. Question is this. Now, they say that only five of the writ petitioners, their names were there, they are there on the portal, they will vote. Rest others, their names are not there for the reason that they have changed their address. You say that they can't say, you are the person who can testify.
No, my
So,
lord,
who will decide?
there is a requirement of submission of Form 7, my lord.
You file your response. Let affidavit be filed.
And
This
the-
time you are
And my
missing
lord,
out on voting.
Election Commission of India, my lord, press note is clear, my lord. Qualifying date is, my lord, 1/1/2026, my lord. There is a,
As per section 23(2) of the RTI 1950.
He
no-
they dispute that they have not changed their address. You were almost, their names were there. Ultimately, finally, you have not put them on the portal, on the ground, but which appears to us to be strange. How can you say, where is the information with you that they have changed their address?
There was an eviction drive, Lordship.
no,
Where is that
they cannot say,
specific
my lord.
note?
If
Where is
they-
just a minute. Where is the evidence shown before the learned single judge that they had changed their address or they were removed, they evicted? Even if evicted, unless they've gone to another place, that section of the Representation of People Act would not get activated. File your response. This is something which is, I mean, nothing can be done before 2 days.
Lordship,
We are not going to permit him only relying on his statement. He should have done that earlier. He should have asked for the court. You should have said that no, in the meantime, the single judge should have done that.
Lordship, they cannot show any eviction notice.
Are we closing down this case? No.
We will examine it.
We are only
And,
concerned,
This
his,
press note is clear, my lord, kindly see, my lord.
So if
Press
that be
note, my
so,
lord,
you will be
published
allowed to
on
vote in
15
terms of
March
the earlier voter
2026,
list.
my lord. Paragraph 5 may be seen, my lord. Qualifying date is, my lord, 1/1/2026, my lord.
take, under this,
And-
under this order of the election commission, go and cast your vote.
Yes, my lord.
Go, what do we do?
Yes, my lord.
Then why
This
have
is
you
clear,
filed
my
this?
lord.
Then why have you filed this petition?
They, my lord, they are not allowing to cast our vote, my
No,
lord.
yes, sir. Then you will go, you show this and you go. If they don't allow you, you miss out on this. But we'll ask for them to respond to this petition. What is your name? MSS, Miss S. Kataki, learned advocate for appearing for the Election Commission of India, shall file response to this file by the next date, re-notify on so.
34 and 35 are similar.
Same order in both. July.
15 July. Daily list for hearing item 12.
Yes,
Lordship, my senior is on VC link.
here is
On VC link. He has
On
joined the
VC.
VC link.
My lord, before
Yes.
starts, my lord,
Hmm.
I would like to say, my lord, they have filed an additional affidavit. So we'd like to respond in that. And second thing, my lord,
You should have told them, no, somebody is appearing from outside.
my lord, actually, I informed my colleague yesterday only that the bigger issue, my lord.
Mr.
For
Who
response
is
of court, my lord.
appearing on VC? Mr. Chaudhary.
Yes, my lord. Back to appear.
Mr. Chaudhary, the counsel for the other side wants an adjournment. He wants to respond. We'll hear you on some other date.
Very well. May I say this, my lords? In fact, my lords, by the order of 14th May 2025, my lords, even Union of India was made a party respondent here, my lords. It is a challenge, my lords, to the constitutional validity of Rabah Hassan Autonomous Council
They
Act.
followed that. You say that the state does not have the powers
Yes.
to.
So, my lords, union say is also important, my lords. Let them also file their say before this court, my lords, as to what they have to say about this, my lords. Because our case, my lords, is that it's the absolute domain of parliament.
All right, Mr. Chaudhary, you also file your response. Take it down. At the request. No, but you say you take the stand that they can do it or they cannot do it. You can take that stand, no? As prayed for on behalf of. Can I mean that? No.
Mr. Dhar.
Mr. R. Dhar, learned standing counsel for tribal affairs, seek some time to go through they have filed what effort to go through the last of the affidavits filed on behalf of the petition.
Additional affidavit.
Last of the affidavits, last of the affidavits filed on behalf of the petitioner before addressing this court. Stop. Mr. Arunav Chaudhary, learned advocate for the petitioner, who appears, who has virtually appeared, Mr. Chaudhary, learned advocate for the petitioner. You are a senior advocate, no? Learned senior advocate appearing for the petitioner submits that the response of the Union of India also would be necessary. Mr. R.K.D. Chaudhary, learned Deputy Solicitor General, shall put in his response as to the correctness, as to the competence of the state legislature to enact the afore noted legislation, which is under challenge.
And
Re-notify.
my lord, one other thing, my lord. The council for the respondent.
या तो आप बहस करिए या take time.
No, my lord. I'm just bringing to your notice, my lord's notice. The council for the respondent number 4, my lord, he has passed away, my lord.
Sabda Rabha has passed away, my lords.
Rabha, my lord.
Okay.
So, my lord, I think, my lord, that a notice should, that is Rabha Hassan Autonomous Council. He was, my lord, on their behalf.
They will file.
They have to take some steps.
All right, we will see that. We are aware that one council by the name of Mr. Rabha has.
Sabda Rabha, yes, my lords.
14-7. Item 17.
Police vacancy वगैरह.
Pursuant to your lordship's last order, my lord, other states have filed, but the state of Assam is yet to file their affidavit.
Who appears for state of Assam?
Mizoram, Nagaland and Arunachal has filed.
Nothing is pending.
Lordship, one status report we have received.
You represent whom? Which advocate? Which advocate?
State of Assam.
Where is Mr. Dinath?
Dinat is from Lake Lordship.
He's on legs. When will you file the affidavit?
Lordship,
Pursuant to the order dated 12/2/2026. It's an old matter. We will not keep it pending. Let's have all the affidavits. Okay, the affidavits as desired by this court 12/2/2026 on behalf of the states of Arunachal Pradesh, Nagaland and Mizoram have already been filed. Mr. The Land Council appearing for the state of Assam submits that all the information has been collated and the requisite affidavit shall be filed by the next state. Okay?
Yes.
Re-notify July.
Much of it.
23rd July. 23rd. Item 18.
27. The process will happen.
Also, this matter, Union of India was required to carry out some amendment in the service.
You had said that they have done it.
Yes, but that was another, there are two matters. pending also.
No, we have passed an order.
There is
Yes.
a-
Formulated this pending sanction of appropriate authorities, which might take some time.
Please see the order dated 27th of January 2026.
Here, concurrence so far as the assistant engineer category is concerned, also, the concurrence of the UPSC has been received. And it is, before the Ministry of Defense and before the Ministry of Justice.
Put on record.
Lordship.
Mr.
So
uh,
it might take some more time. Lordship.
Mr. R.K.D. Chaudhary, Learned Deputy Solicitor General of India, submits that despite the formulation of the rule with regard to the service condition for junior engineers in the border roads engineering service, those have not been rolled out for want of necessary concurrence from appropriate authorities, which shall be forthcoming shortly. Let this matter come up again for consideration or sometimes in July. By that time, you will roll out, no?
I should be done.
July end or August kingdom.
By that time, they are doing something.
Try and understand. This is not a mandamus. They have themselves formulated the rules. This is only in keeping with the service jurisprudence that there should be some avenue for promotion or in situ promotion with financial adjustments. When we can't pass an order, can we pass a mandamus for the state to come up with a rule? If they make a rule, if they don't make a rule, we'll only indicate to them. So if they say that they are making it and it is only the rollout of it has not been possible because of lack of sanctions which they are doing, we are bound to give them time, no? No interim order can be passed here. Chalo.
4th of August. Item 21.
This matter relates to selection of
इसीलिए ना बिना लिखा है वो।
an LDMI.
An old order of 26/11/2025 indicates that you have made arguments or earlier.
Yes, ma'am.
We are in the practice of, stating everything, what the case says. We don't remember. You'll have to argue afresh.
Sir, पहले देखिए respondent, education and private respondent. बाद में आके बोलेगा adjournment.
और लोग हैं. Others are here. Who appears for the respondents?
4 and
How many respondents are there?
then education, 4 and 5.
There are 6 respondents, my lord.
Pending council education.
4 and 5 now.
My lord,
Who appears for respondent number 6? Arifuddin.
my lord, on a previous occasion, Mr.
Notice must have gone, no? Otherwise it would not have been kept for hearing.
Arifuddin is that inspector, isn't it?
Yes.
So he can
Who is for the standing education?
In fact, my lord, I concluded my, I'll argue again, but I concluded my argument.
We
Thereafter-
don't remember anything.
I-
So sorry, we did not note it down. But henceforth, we'll be noting it in every case. We do it in every case, but I don't know why it was not done.
The re-
Just a minute, give us a minute. There is some scribbling in the note. Who appears for the education department? Nobody appears, no? Somebody was sitting here. Mr. Sharma, you don't appear, you don't represent education department. You don't represent education department. So this exercise again, Mr. Chaudhary would not be. Okay, Mr. Chaudhary, Mr. M.K. Chaudhary Leonard, senior advocate for the appellant. And Mr. M.S. Mandal, learned advocate for response number 4 and 5 are present. There is no representation on behalf of the education department, which would be necessary, let this matter come up for consideration under the same heading on. We'll put it after some time, unless there is some urgency in the matter.
Not really, my lord, there is an interim order protecting me, and that may be.
Interim
extended.
order in the meanwhile shall continue. We'll give it in May end or June. June.
11 June. Item 22.
Matter may be fixed at two, my senior, he just.
Matter may be fixed at
Two, Lordship.
2. Why?
Lordship, my senior was at Delhi, he have landed few minutes back, so he will be arriving there.
Not today. Then you get another date. This is not the way to, you file your written, you have filed your written submissions and all.
Lordship, it was filed.
It has been filed. We'll keep it at 2. We are assembling at 2 because there is another matter.
On the way, Lordship.
Okay, okay, all right, at 2. Bas khatam karenge. Yes, Mr. Chaudhary. We will first take up the Sikkim matter.
Wait, please, last.
Yes.
Lord, on last occasion, basically what we tried to argue was, Lord, that despite repeal of the second subject regulation of 61, efforts were made by the state to give COI or residential certificate, whatever nomenclature we may use, to give them their due share. With that end in view, an exercise started in 1976.
That is where the problem lies.
No, I'm coming with that.
All right, we will give you uninterrupted time.
Now, that is how it all started. Then, my lord, in 1995, they came up with that notification where the lordship will find, if the lordship could kindly have my written argument, which I gave the other day, a small one. Please come to this second page, my lord, repeal of sitting subject. Now, para 7, we refer to that regulation whereby.
One second.
Yes,
Yes.
that, yes. By para 7, my lord, we refer to the sitting subject regulation by which it was repealed.
Hmm.
And most important is para 8. In spite of, my lord, it's my formulation, my lord, in spite of the repeal, what the authority did, they issued this memorandum. Now, my lord, most importantly, when they wanted to make provisions for employment in favor of a non-citizen, despite existence of the 74 rules, why? A question normally arises, my lord. Why, assuming, my lord, these measures are aimed at providing employment only and for no other purpose? But on the face of, my lord, statutory bar, 371 F K,
How come, my lord, provisions were made for employment? Now, what I have tried to say, my lord, following the repeal of the Sikkim subject regulation, the issuance of memorandum dated 25/9/76 became necessary for identification of Sikkimese locals. The said memorandum referred to term government relevant register, which included Sikkim subject register, electoral roll, employment record register, land patta records, etc. The use of the broader expression government relevant register clearly indicates that the intent was not to confine to Sikkim subject register alone, but extended to other official records maintained by the government. This is validated by inclusion of people in the above categories in the subsequent notifications. This broader classification was intended to identify a person who were otherwise eligible to be recognized as Sikkim subject, but whose names were not recorded in the Sikkim subject register, particularly in case of genuine omission. So, my lord, this is how the matter stands. And if your lordship would kindly have for a moment the writ appeal, page number 185, my lord. 185 capital A. This is how the exercise started. In order to ascertain the residential qualification of candidates who claim themselves to be local at the time of seeking employment, it has been decided that candidates should be asked to mention whether their parents' name have been recorded on or before 15/5/75 in the relevant government register. If the intention, though it is an executive fiat, my lord, if it would have been the intention to refer to Sikkim subject regulation or to the Sikkim subject register, they could have clearly said, my lord, when the authority is referring to a particular document, then they use the suffix, my lord, relevant makes the position very clear. Relevant government register, meaning not that SSC alone. There are other registers. Now, at page 187, my lord, the position becomes clear. Please come to page 187. This is despite the rules of 1974, which says that when it comes to employment, it is only the Sikkimese will get a preference, others will not get. In the modification of department OM dated so-and-so, the governor has been pleased to authorize district collector within the respective district to issue certificate to persons identifying them in the following groups to enable them to apply for employment in the state. A person whose name is found in the recorded in the old Sikkim register prior to 75. A person whose name is not found in the register, but she has established beyond doubt that the name of his or her father, grandfather, paternal husband, paternal grandfather, brother from the same father has been recorded in the old Sikkim register. A person who has agricultural land in the rural areas and has ordinarily been residing in the state of Sikkim. A person whose father, husband has been in the service of the state government on or before 31st of December 1969. Now, my lord, if your lordship will kindly see this 2, 3 and 4, they are otherwise eligible for inclusion in the Sikkim subject register under 61 regulation, but left out due to omission.
No, that comes later. That aspect comes later with the passing of a bill in the Lok Sabha and thereafter coming up with this.
Look, that is
This
the
is-
exercise of 89.
That's correct.
It subsequently also
So it all,
fine.
so that's all right. It all began with, you have a ground there.
Yes.
That it all began with 1976.
Yes.
Identification.
Yes.
And then sometimes in the year 1980, they said that identification certificate given by district collector only would be valid, rest
Yes.
not. Till this time, they don't talk about only for employment.
Yes.
They say for mention whether their parents, in order to ascertain the residential who claim themselves to be locals, Correct.
Right.
This is for locals. Now,
No,
locals
81
at the,
speaks of employment.
it does, but in a peripheral way,
Yes.
because it says that locals at the time of seeking employment. So at the time of seeking employment, otherwise, so it can be related back to that. Now, just a second, what I am driving at.
6 months.
My brother says, and rightly so, if you make a distinction, then we also make a distinction. So this is in order to ascertain the residential qualification of candidates. Candidates means those who have already applied and not citizens in general. Anyway, we are
Yes.
giving that latitude here.
Yeah.
We are not sticking to that. I think this is the fecundity of my,
We'll have
this
to
is just a
start off
minute.
and
This-
proposition, reading the whole things as
Correct, correct. This is the fecundity of my brother's imagination, and there is a ground. He says, at the time of seeking employment, therefore, if we read the second line, probably what my
reading which one? Lord? Page
come to 7185A, where it just,
185A.
yes, when it just
In
began.
order to ascertain
Uh,
of candidates who claim themselves to be local.
No,
Yes.
no, he
In
says
time
that
of
in order
seeking
to ascertain the residential qualification of candidates.
Ah.
Candidates means not the general citizen, but candidates who had applied for government employment.
As local.
Seeking employment.
And then, you know, why it can be thought of like that? Because the second line says, who claim themselves to be locals at the time of seeking employment.
Yes.
So therefore,
So
it all began with employment identification. Now,
Yeah.
correct.
No.
Now, in 1980, they
There
say,
one thing has to be noted, my lord. Under the rules of 1974, which we have all seen it, my lord, when it comes to employment, the locals will get it, nobody else will get it. In case local is not available, non-local may get it, but the moment a local becomes available, he or she will have to make room for the local. Now, my lord, if for identifying local, SSR is there, why other exercise is required? Seeking subject register is there. If their intention is the person whose name appear in seeking subject register alone are eligible for everything, others are not, that these are notifications and only for the purpose of
so
employment,
this is
then why are you making this distinction? Why are you carving these classes?
this class has been included.
Yes.
Because apart from other things,
Hmm.
suppose somebody's name would not have found mention in the old Secumis register, maintained under the regulation, which
Yes.
after its repeal, whatever has been done is saved by the General Clauses Act. Or anybody has agricultural land. Correct. So for the purposes of qualifying and limiting this, for the purposes of employment, this also was added, that anybody whose father or husband.
No, to that, we have no quarrel with that. All that we are trying to say is, in the process, what you are doing, only in respect of serial number 4 at that 9181 notification, you are making a distinction over them, others you are retaining.
No.
And it's similar. Yeah.
We
Other than 4 at page 187, everybody else is getting everything.
no, they are getting
Even persons under 4.
to hear our objection to
Yes.
this argument.
Yes.
Then only you will be able to build upon it. That number 4 we will get at,
Page 187 number.
no. We will get at page 195.
No, first is 187.
187.
Yes.
A person whose father or husband had been in service of the state government on or before 31st. Correct. So
This is the beginning.
till such time, no distinction according to you has been made.
Yes.
Correct. Now, the other notification comes.
At page number 195.
Yes, that is what I was referring to. 195. Last, a person whose father, husband had been in Sikkim government service on or before so-and-so, certificate of identification obtained by such person shall be for the purposes of employment only. This
Yes.
is being done for the reason that a person who's person in serial number 1 or 2 or 3 or 4, they are eligible for other things also because their names would have found mention in other registers. They're good for everything. By virtue of this certification, they don't get access to other things which they are otherwise getting because of their entitlements. Now, this is only for the purposes of, it is for this reason that it is only for the purposes of, identifying a person whose father, husband had been in Sikkim service, because this is a special class in recognition of the services rendered by their predecessor, by the husband or the father.
Let us read the first paragraph very carefully, Milord. In supersession of the memorandum dated so and so, so and so, so and so, and circular dated so and so, state government is hereby pleased to authorize district collector, subdivisional officer and revenue officers within their respective jurisdiction to issue certificate of identification to the persons falling under different categories as indicated below on recommendation of the Gram Panchayat being duly satisfied with such recommendation.
I can see, because this introductory part does not talk about employment, and therefore the confusion. Now the argument is, your argument on the other day was, if I am able to recapitulate that till the time it dawned upon them that these persons also are taking advantage of this certificate of identification by asking for, permission to sell or permission to purchase, or for getting a quota in medical institution. They made it very obvious that now this certification under the original 1976, first of the notification for identification, see, I would be identified, but this identification, because of my being either wife or son of a government servant, I mean, this should get me access to other privileges,
Yes.
like a local. The difficulty here is that Mr. Day says that no, these people, person whose name is recorded in Old Sikkim Subject Register, suppose those 18,000 applications which are pending before the committee, you are considered to be a person whose name was wrongly added. You get into this category.
1, 2, 3, 4.
1, 2, 3, 4. 1, 2, 3, 4 are persons sans any trace to the service of their father or wife. Therefore, there are three things here. If number 5 is read in isolation, and the last line, certificate by such persons, whether such persons is these persons also, that also we cannot make out.
The question which is begging an answer according to me, subject to what our losses may say is, now by way of an executive fiat, you are making this classification, which according to us is discriminatory. Why? How can you confine us to only employment to others you are not? I can appreciate, my lord, whose name appears in Sikkim Subject Register.
Difficulty here is that we cannot lose sight of the fact that we would have,
No, the
we would have
argument
gone,
which I'm advancing is
we would have
only for the
gone.
purpose of bringing home the
Correct.
point that there is discrimination.
Difficulty is that you can't see it in silos. It
Oh,
can't be seen in. No, you have to perforce. We have to look at it. Now we would have otherwise gone with you. Even today, I mean, we have gone with you means, for argument's sake, we would not have questioned you. The difficulty here is the act of, what is that? 1974, Establishment Rules of 1974, that having been ratified in Surendra Sharma, that having been ratified, and 371 capital F.
Yes.
Now, entire thing has to be seen in that background.
And most importantly, my lord, whether 371 FK has been followed. Please have the constitution, my lord.
Yes. Therefore, we take down your argument
Yes.
that this is a special classification made by an executive fiat,
Yes.
which could not have been done,
Yes.
notwithstanding 371F
Yes.
and recruitment establishment rules of
And
1970.
more particularly, my lord, having regard to subclause K of 371F. Please have that, my lord.
Constitution.
All laws in force immediately before the appointed day, that is 26th of April, my lord, 75, in the territories
Yes.
comprised in the state of Sikkim, or any part thereof shall continue to be in force therein until amended or repealed by competent legislature or competent authority.
Hmm.
Now, KL also.
Hmm.
For the purpose of facilitating the application of any such law, as is referred to in clause K in relation to administration of the state of Sikkim, and for the purpose of bringing the provisions of any such law into accord with the provisions of this constitution, President may within 2 years from the appointed day by order make such adaptation and modification of law, whether by of a repeal or amendment, or as may be necessary or expedient, and thereupon every such law shall effect, subject to adaptation and modification so made, and such adaptation or modification shall not be questioned in any court of law. So, my lord, K is the substantive power, and how it will be done, it is indicated in L. Now, the question is, my lord, the pre-existing law has been saved. And we say, even though you have repeal the second subject regulation, but you have, if the provision will be saved by virtue of section 6C. So our right flows from that. Now, there in the process of tinkering with our right, can you issue these executive instructions to, my lord, tinker with our rights? That is my first and fundamental argument. My second argument is, my lord, the effort which you started in 76 was to identify the persons who were omitted to be included in the second subject register. Now, in the process of identifying, you never confine yourself to only persons whose names are recorded or whose names should have been recorded on account of XYZ reason could not be done. But it also includes persons, my lord.
If, correct, we see some logic, we
Yes.
see a logic there. But the difficulty is that this now, even if it is being made for a particular class for employment,
Yes.
that is saved.
No. We have no quarrel with Surendra Prasad Sharma.
We
Sir,
can't have,
Surendra Prasad Sharma.
we can't have, we can't have any quarrel.
No, Surendra Prasad Sharma, what was the case then? Where the learned single judge of the Honorable Sikkim High Court, without having due regard to 371 Act, based on, that is single judge.
It is, yeah, I'll tell you.
Based on Article 14 of the Constitution
Correct.
of India, interfere.
And this all happened. You see, what had happened was that they advertised for posts in the land department,
Yes.
land revenue department. They were appointed, that was temporary appointment, which was conditional upon having work to be completed. It was only for that period. Later, it so happened that after the work was completed, some of the persons were asked to exit. And these were only such persons who were not locals, Sikkimese locals. That was questioned.
Now,
Then the Sikkim High Court said, single judge said that, well, with the merger, all these things go. This was the occasion for the Supreme Court to examine 371F. Correct. This is the background.
Here,
Your argument we have understood by virtue of the adaptation and by virtue of the fact that you were given the citizenship status, because if your forefather, children, if your
grandfather and father.
it is not even for grandfather, if your father and husband had been in service.
Yes, brother.
That is not being changed. Because what is being changed now is not the father and husband or brother, but it is now for the grandchildren, number one. And number two, for such persons whose names, even if they fell in that category, their names somehow the other, because that time Chogyal was conscious. His monarchy knew about the fact that he is the son of a government servant who has helped Sikkim grow out of this era of darkness or whatever.
That is why this special privilege was extended to people who serve the Sovereign.
Can this continue for perpetuity?
Lord, will it not be a manifest arbitrariness? All of a sudden, the branches are cut off.
Have they said
No,
that? Have they said that you don't?
Let us
You are
have a
not
look
for.
at
You are not
section.
fit for. You can't stay.
Let us have a look at section 3 of the Indian Citizenship Act.
they follow.
As far as Assam is concerned.
The fallacy here, I am not
Yes.
able to proceed further, only for the reason, therefore, this is the stumbling block. They don't say that this certification, if you don't fall in this category, you don't fall in other entitlements also.
No, no.
This is an administrative structure identifying a person who is eligible for government appointment, whether he is a local or non-local.
No, no, our grievance is in the name of identifying persons who are eligible for government job, you are taking away our other rights which we are enjoying.
For other rights, you have to go to other places. Either, and for other rights, for vindication of other rights, you have gone to.
I'll place the cabinet decision that will make the position clear. Please have the repetition for the option. That cabinet decision, which was taken in 2010. Please have the writ petition, my lord. This will make the position absolutely clear. Look, today we have filed an affidavit where we have brought on record how, my lord, we are.
You want us to go through the affidavit
Or
or the
first cabinet, my lord, the cabinet decision starts at page 202 of the writ petition. My lord, you kindly permit me to read this, the first part, then I will come to the decision. This was on 21st of September 2010. Concern have been expressed from time to time by various groups of people in the state regarding grant or denial of certificate of identification or residential certificate required for a variety of purposes like employment under the government, admission to school and colleges, trade licenses, taxi permit, ration card, etc. There is persistent ambiguity, non-uniformity and inconsistency among the issuing authorities regarding eligibility of person for issue of these certificates. It is therefore necessary to prescribe clear guidelines for issuing authorities so that no genuine person is denied his or her entitled certificates and no unauthorized person gets one. The issuing authorities have also sought some clarification regarding issue of COI to the next generation of Sikkimis, as the present notification relating to issue of COI provides for a relationship only up to paternal grandfather. Similarly, a woman married to a Sikkimis will be entitled to COI only if her husband's name is in the old Sikkim subject register. There is no provision for cases where husband's name is not in the old Sikkim subject register, but his father's name is recorded in such a register. It is understood that COIs are being issued to such next generation of person, but there is no provision to cover such cases under the present notification. There is also confusion amongst the issuing authorities with regard to following cases which needs to be clear. COIs have been issued to even foreigners on the basis of Sikkim subject status of their husband or paternal grandfather or brother from the same father. Legally, a foreigner should first acquire Indian citizenship before a CI can be issued. Persons domiciled outside Sikkim who could not have qualified for grant of Sikkim subject status under any of the criteria fixed for determining the same, so-and-so, or the one adopted for later inductee as per 1989 order, have been issued COI on the basis of Sikkim subject status of their paternal grandfather or brother from the same father. District collectors have also expressed the need for a provision to cancel a COI if it is satisfied that the same was obtained through misrepresentation or suppression of any material fact and the need to guard against the wrongful issue. An appellate authority for such cases may also be considered by notification of so-and-so is to be considered on the recommendation of the Gram Panchayat. Provision has also been made for Nagar Panchayat municipality. Apart from the COI, the district collector have also been issuing residential certificate to people residing in the state for the purpose of employment under the Government of India or its PSU admission to school and colleges ration cards. These certificates are, however, qualified by suffixing the purpose for which these have been issued. These certificates are needed, but there are
no set of rules or guidelines governing this issue. The above issues were discussed at a meeting held under chairmanship of Chief Secretary on 2/8/2010, and it was decided that necessary provision may be added in the 1995 notification relating to issue of COI. For remaining persons who are able to establish beyond all reasonable doubt that they were residents of the state of Sikkim as on 26th of April 1975 and have been residing therein since then, and their natural legal descendants, and such other persons who are similarly placed in the matter of residence, having residence in the state, may be issued with a residential certificate. Now, paragraph 7 is very important, my lord. In regard to the benefits that will accrue to the above certificate holders, it is submitted that following benefits are and will continue to be exclusively available only to Sikkimis as listed under various categories in the notification relating to issue of COI in view of the still valid pre-merger laws on the subject as they enjoy constitutional protection under Article 371F. So, my lord, what I understand from para 6 and 7 is very clear. That means this, what are the rights which will accrue to the above certificate holder? That will continue, that is, these are the two, my lord, employment under so and purchase of so and so. But regarding the others, my lord,
Come to 9.
yes, the holders of residential certificate may be considered for remaining benefits. In any case, this would be as prescribed by the concerned department. My lord, we are not claiming right to employment under 74 rules, my lord, which is exclusively for the, so and so. We
Okay,
say
okay.
we should be given other rights.
Get a residential certificate.
My lord.
Get a residential certificate. Get a residential certificate. Where is the difficulty? If you're not claiming employment as a local, get a residential certificate. They are giving you.
No, residential certificate. No, one second. Milord, what I understand is, Milord, we have not been issued residential certificate also. But residential certificate is as good as nothing, Milord. We can only stay. We can't do anything.
For all benefits.
Yes. Milord,
Purchase of a movable property, you get it from the land department.
Position which was obtaining on 981 to be restored. That is our case. Because by virtue of the 1981 classification, we are getting everything. To that effect, Milord, today we have filed an affidavit. If your lordship would kindly have a look at that.
इसको flag कर देना. Page 202. Yes. Flag it here.
Page would be, Milord, 588. It starts. The other day we made a submission.
Affidavit is where? New affidavit which you have
Milord,
filed?
it starts at page 588.
मुझे separate बस
Separate करके निकाल के दे दो.
दे दिया है सर है इसमें है
Milord, will kindly come to page 593.
नहीं ये नहीं है. ये तो आपका है. लो नो. वो तो कर दिया. 59 new affidavit which has been filed. It is not here. Yes.
Yes. Milord, will kindly come to page 593, Milord.
Yes.
It's a document of 29/11/85. We have given the type copy, original is at page 594. This is to inform you that Jogesh Verma, son of so-and-so, was a government of Sikkim nominee who was allotted a seat in the MBBS court against reserve quota in December 77. So, my lord, the medical seat was given as a nominee. This is in proof of the fact that we are also enjoying benefits like others. It was only when this 95 document notification came, my lord, we started
This
filling the
is-
things.
this is-
Then again at page 595, my lord. to the principal Aryabhatta Polytechnic, New Delhi, and to invite a reference to the Ministry of Department of Human Resource Development, New Delhi, letter with so.
This is now, if you had said, if this notification would have said, if this communication would have said that this we are sponsoring because he has a certificate of identification under 1976 and continued till 1995-96, we could have understood. This is, the sponsor is made, I mean, they could sponsor
No, no,
somebody who is, who has a residential.
Unless I'm a subject of seeking, this is not available. For example,
But
tomorrow
not
my
necess-
daughter cannot apply for
Suppose
seeking
not,
quota.
not necessary that you have to be son or wife of a government servant. For residential certificate, you can have if you obtain, if you have purchased property in the past.
Yes.
Ordinarily, you reside. Or if you have relinquished the citizenship of other country. So many things. If you're born, these are citizenship things. Now, therefore,
I'm on a slightly different point.
no, we are getting back to the same thing. Now, suppose this sponsor would have been based solely on COI.
Yes, it is only on COI.
से दिखता नहीं है.
No, it is only on COI. Otherwise, the state of Sikkim will not sponsor. Because the other day, our argument was, my lord, until 81, everything was okay. We are getting all benefits. It is only after 95, my lord, that they were trying to confine us
But
to
this benefit that you're getting is not restricted now with COI clarification. You keep getting benefits.
cannot
No,
now.
that is not a question.
Now we are not even being, my lord, sponsored. That will not be sponsored because I am not in possession of a COI. My parents. Now, for everything we need a COI. My lord will kindly see the entire history of this litigation. But for this sudden takeover by government of India, things would have been different, my lord. All of a sudden, one fine morning, the decision comes of merger. Then everything becomes topsy-turvy. My lord, can you appreciate that, my lord? Where do we go? My lord, there was a time, there was nobody to rule the state. We people went there. We extended our services. In recognition of that,
government servants during that period would have died.
my lord,
All government servants during that period would have died.
what will happen to
Their sons, only their grandchildren and
sons
great
and daughters,
grandchildren.
grandchildren? Well, will it not be a manifest arbitrariness to, I mean, the
You'll
split
have
of
to,
the
you'll,
benefit
you'll
of a
have,
particular state?
you'll have to have the law changed, no?
Where is the law that I will not get it? By executive instruction only they are
No,
doing all
this is
this
not
thing, my lord.
executive instruction. The law which permits executive to frame a situation whereby employment would be limited. Other things, you challenge it for other things, we'll say.
No, my lord, our humble submission is very simple. You have repealed Sikkim subject regulation. At the same time, you adopted the General Clauses Act. So the implication has to be applied. So all that we say.
That is the major plank of your argument which has kept this petition running.
Yes.
Correct.
Look, all that we say is we accrued some right. Those rights are preserved. So we want to enjoy that right. So Lordship will adjudicate whether those accrued right includes the right which we are presently projecting before your Lordship. If your Lordship says yes, we get through. If your Lordship says no, in the process we say that the state is trying to make a discrimination based on some executive orders which is expressly illegal. Well, can by an executive order all these decisions be taken when under the Lord adaptation order the rights accrue otherwise? So, therefore, now what has happened? A situation has come. On one hand, there is a statutory framework. On the other hand, there is a set of executive instructions.
Then by virtue of that, the prohibition is Sikkim. They become Sikkimese for all purposes, including employment. Very expensive. That is very expensive.
So, Lordship, just kindly take para 83, single judge's judgment, Miller, page 83 of the single judge's order. Sorry, I'll have your Lordship sign attention to page 82, para 30. No information was forthcoming to the query made by the Chairman Law Commission. Instead, the file mandated in the path to the office of the then Learned Advocate General, who required the Additional Chief Secretary Home to provide all notification along with relevant file to enable him to determine the object and intention of the impugn amendments. This request too met with the fate of stonewalling in as much as Undersecretary to the department informed the Additional Chief Secretary that the file in which the matter was dealt with in 95, being so-and-so, was untraceable in the department. Failure or reluctance of the government to furnish the file undoubtedly leads to an adverse inference. Following the development, Honorable Justice so-and-so gave an opinion divergent to that of his predecessor in the office of Justice Patra. Strong reliance was placed by state government on the opinion rendered by Honorable Justice Bhattacharya, Chairman Law Commission of Chitty. However, on careful perusal of his opinion, which was reproduced in the counter affidavit of the state respondents, it contains no reference or specific as to why he was of the opinion that third generation of.
This is with respect to grandchildren. This is with respect to grandchildren.
Grandchildren, yes. Then will have kindly come to para 31. From the entirety of facts, para 31 and circumstances supra and the discussions herein above, although it is submitted by state respondents that insertion of the category in item 4 of the memorandum of 81 and item 5 of the notification of 95 was not prompted by provisions of the regulation of 61, silence resounds on the reasons for such insertion. No document, file noting, revealing the reason for the policy of the state government or any other evidence was forthcoming for the perusal and consideration of this court. Indubitably, after the merger of the Sikkim, regulation of 61 came to be repealed. Despite circumstances, the category in item 4 was inserted in memorandum of 81. In other words, post-merger, there was indeed no requirement to include the category, but state respondent in his wisdom did include them. Once they have been so included, it is indicative of an implied acceptance of the petitioners by the respondents as seeking is and thereby legitimate expectation on the part of the petitioners to be treated as such. The respondent states contention that it was one-time concession to that category is unfathomable since Rule 4.4 of the Establishment Rule 74 already provides for employment to outsiders if competent candidates were not available against the Sikkimists. It is not the petitioner's case that Chogal had granted them citizenship. Nonetheless, it is only the legitimate expectation based on regulation of becoming Sikkimese, a promise writ large in the regulation and circumstances of merger being unforeseen. Post-merger, therefore, it was incumbent upon the state government to have addressed the specific case of non-Sikkimese governments and their status. Instead, as already stated, they were included in the memorandum of 81, devoid of any caveat, which led to an assurance and affirmation of their status as Sikkimese. The memorandum of 81 is the result of a government policy which nowhere elucidates that one-time concession was extended to the category in item number 4 of 81, thereby preparing them for eventuality of the notification of 95, 96 and 2010. The notification of 95 being in supersession of memorandum of 81 effectively replaced its content and was a bolt from the blue for the petitioner, who I am of the considered opinion cannot not be shortchanged by insertion of a qualifying sentence. It was the argument of the state respondent that in any event the memorandum of 81 was only for the employment too. But when this superseding notification was issued, no reason emanates for placing them at item 5 differently from other categories by limiting the use of their COI to employment only, while no such restriction emerged for other categories. The argument of Learned Advocate General that only those persons whose parents' names were recorded on or before 15/5/75 were seeking the stand belied by the introduction of that category in item number 3 in memorandum of so-and-so, from whom the merger bar of descent is mentioned as a criteria. Neither any cut-off date exists. They only recommend the possession of agricultural land. So therefore, my humble submission is that
In that case, Mr.
Yes.
There's an argument which resonates, correct? Now, let me put a question to you. Now, in that case, Surendra Prasad Sarma, we are not talking about the judgment, we are talking about the facts. Surendra Prasad Sarma, he got into service post 61. post 75. Correct. And thereafter he was not treated as, so do you think monarch had included this for perpetuity for all times to come?
No. Surendra Prasad Sharma's claim was not based on all these things.
Now, it was based on he having entered government service
Yes.
because of no Sikkimis being there. Now, the same,
Only question there was, my lord, that whether any such reservation can be made in favor of Sikkimis. Let us put it this way. And the learned single judge of the Sikkim High Court examined the matter only from the perspective of Article 14 and 16 and came to a decision which came to be, my lord,
reverse.
level to Supreme Court and reverse. Here, my lord, we say we are deemed citizens. We are deemed, Sikkim subjects. Somebody's name appears in the certificate or the register. He is a, my lord, expressly his name finds place. Therefore, there is no question. And we say we are deemed under these circumstances. Therefore, all that we want is our.
Once again, let us see that 61 regulation.
Yes. 61 regulation is at page, my lord. Page number 92. 4 it starts, my lord. 94. Page 94, my lord. Section 3. Regulation. Certain persons domiciled in Sikkim territory at the commencement of the regulation to be Sikkimese subject. Every person who has his domicile in the territory of Sikkim immediately before the commencement of his regulation shall be a Sikkim subject. B was born in the territory of Sikkim subject and is resident therein. And see B below. Has been ordinarily resident in the territory of Sikkim for a period of not less than 15 years, immediately preceding such commencement.
No, let us come to that is not in dispute. Now come to
No, my lord,
page
all
96,
that I was-
8,
no,
naturalized.
For a moment, Lord Smith, can you permit me to make one small submission?
Hmm.
Now, even for resident, you need to live 15 years prior to coming into force. That means from 1946
And for government servant only 10. Now come to 8,
8.
page 96.
Three. The government of His Highness shall also have the power to naturalize a person upon application made therefore in the manner prescribed by the rules, provided that the government of His Highness has satisfied that he has been in the service of the government of Sikkim for a period of not less than 10 years, immediately preceding the date of application. B. He has rendered meritorious service to the state, and the person to whom such certificate is granted shall, on taking oath of allegiance and upon his name being entered in the register of subject, be naturalized Sikkim subject from the date on which the certificate is issued. So, my lord, those who served the government, they were given a higher status than person by domicile. Before making the application, whosoever had completed 10 years,
We must read the entire thing. Number one, there was some confusion in the arguments before the Sikkim High Court when this was understood as in the service of the government of Sikkim for a period of not less than 10 years.
Lots of this reading, Miller.
I am reading 3.
3.
The government of His Highness shall have the power to naturalize a person upon application made therein in the manner prescribed in the rules, provided the government of His Highness is satisfied that he has been in service of Sikkim for a period of not less than 10 years immediately preceding. Now, this is not qualified by second clause that he has rendered meritorious service, as has been understood by the learned single judge in Sikkim. Or he has rendered meritorious service to the state, not necessarily for service, because it is not and. It might, by construction, it can be said that it's and the person to whom such certificate is so and so. Now, read 4.
The government of His Highness may at the same time naturalize the wife and minor children of a person who is granted certificate of naturalization.
Correct. So otherwise
application
this would have said that for perpetuity, all his children, grandchildren, great-grandchildren will be there. How do you say this? I mean, we can't read anything more than this.
No, my lord.
Read it again with keeping you aside from the position that you're holding.
Yes.
We are not
Because-
deciding, Mr. Chaudhary, for you or for Mr. Dev. We are not doing it.
Yes.
We would love to decide in favor of you. Everybody should get equal opportunity,
Yes.
whoever in the confines of the country.
Lordship's tentative observation
Hmm.
that in the regulation, it could have included all the generations to come. It has not.
They say wife and minor children.
Yes.
So therefore, wife and minor children who would be existing at the time when he is naturalized.
No, my lord, I would say 4 was an enabling provision. It was left for the executive to frame rules to carry out the purposes of this act. By giving the guidelines. May. So this was not a substantive provision that way, my lord. It was only left to be further, my lord, exemplified by your the rules.
The application therefore is made,
Ah.
then the wife or so and so can also be.
Will
So it's
also
not
get-
automatic that the husband is given, so his wife and minor shall also be necessary.
No, my lord, I was just trying to visualize a situation. Supposing I am grandson of a government servant, I get the benefit. The moment I get a certificate of identification, otherwise as a citizen of India, I am within the state of Sikkim. I am not seeking any political right to contest election. All that I want is, I should be allowed to, my lord, own a property. I should live there, and my children and all should get an opportunity to take part in different activities, including admission to government colleges.
But by which 5(8), by which law?
It is not our case that, my lord, 371F also carves out some exception regarding the political right. Those are sacred. There we are not trying to tinker with, my lord. All that we are saying is, since we are otherwise citizen of India, Sikkim is a part of India, certain rights, certain prescription has been made, and we fulfill those prescriptions.
But
Therefore,
suppose,
please extend those benefits
suppose
to
they
us.
don't, suppose we are just asking, suppose they don't grant you COI because you don't fall in that category. If they don't grant you COI, then there are other mechanisms to get those benefits. No, you are an Indian citizen domiciled in Sikkim. Because that ground also weighs.
But in-
Domiciled in Sikkim. See, this excludes.
If I have a COI, in that case,
Suppose this COI would have been used at one point of time. Suppose. Now, the comparison may not be apt, but we are only trying to explain ourselves. Suppose Election Commission of India issues a card. If a person does not present that card by Election Commission of India at the time of polling, is he asked to go away? No. He is asked to produce anything, including a driving license.
I can't get a driving license also.
But that's a different thing. That's an example. So therefore, you, by this certificate of identification, limiting it to only to the wife and son under a special circumstance, because 1961 thing, that was adapted, all transactions concluded, it is saved. Despite the repeal, it is saved. For including that, they have added this number 4.
Yes.
If we see it in this direction, then can we say that they have gone beyond the mandate?
No, no.
From 1976 onwards till 2010, the common thread is employment. That is where we are stuck up. Now we wanted to have a way out.
No, Lord, my submission is whatever position was obtaining on 9/8/81, let that be restored, my lord.
No, but why? That is, if suppose a
Because-
suppose a functionary of a state wrongly uses that certificate, wrongly allows that certificate to be used for other purposes, can it be perpetuated?
My lord, kindly see, to say for facilitating employment, all this exercise was done on the face of rules of 1974, that too which was, my lord, adopted by the.
Yeah,
in terms of
perhaps we are
371F. Does it make any sense?
No, it doesn't.
I understand.
No, but it doesn't make any sense. So 371F should be deleted.
This not should be deleted. My lord, question is, you say you are trying to carve out an exception for facilitating employment to non-citizens.
Suppose naturalized, when your grandfather,
When the
suppose when your grandfather was naturalized,
Yes,
suppose I take illustrative example of a grandson who has not been given COI. Now, his grandfather was naturalized in 1961. His right would flow only from there. Now, at that time, the monarch was very clear that this will flow only to the son and not to his sons.
matter can be viewed from another angle also.
Can it be viewed from this angle?
Lots will kindly see,
Hmm.
if we lay more stress on regulation 4 of repeal regulation of 64, Lord,
Which repeal regulation?
no, this
61. Rules are 61, regulation is 61.
No,
Both.
all that I'm trying to submit is,
Hmm.
it will lead us to nowhere. Because end of the day, my lord, which is that statutory provision which is dividing us, other than these executive instructions? Which is the statutory provision, which either government of India or state of Sikkim has framed?
Let us put it differently. Which is this decision which is excluding you from being the descendant, from being the wife or a son of a naturalized?
Executive instruction.
No. It was given only to that till that level of descendants. Nothing beyond.
No, my lord,
Otherwise, you show from 1960. Therefore, we got to 1961.
all that we, no, look, all that we are trying to say.
Could
is,
it not have said, and naturalize, could it not have said the government of His Highness may at the same time naturalize the wife, minor children, and the descendants of the person who is granted a certificate of identification? They would have said that. Why it is limited to only this?
No, no.
Because this natural, that time the Chogyal did not know, though of course it came only a year later. 61, it came about 14 years, 15 years later. But he knew that these are the persons who have helped. They have helped Sikkim to be run. So let them take the benefit. And because that time not necessarily all would have been bachelors, they would have married, so their children also. Keep them. In every likelihood, they would be born in Sikkim.
But if Lordship wants to give a meaning to.
I don't want to.
regulation,
We don't want to give a.
Section
We
4.
don't want to give a meaning. We want to learn from you what meaning should be attached to it.
So, Lord, my humble submission is.
Question
for-
is,
For understanding our projection, my lord,
if they say that, well, if you have house, if you have property in the rural area, you sell it and go away. You come back to court, notwithstanding anything, we stop it.
It's not a
It's
question of.
difficult.
No,
You
it's
have
not a-
all other rights because you want a right under the COI for being appointed, and you say that you're not wanting it for employment. You're not interested. You're only interested in leading a citizen's life where you would have all the other advantages.
Same time, where.
Therefore,
Possible kindly see, because my forefathers,
it's your-
they went to Sikkim only to serve the government. And government promised us something. And today, my lord, can she land up like this?
ये तो बहुत मुश्किल है. ये this you cannot take to a big distance. They कहाँ से होगा? But now the promise which they had made, it was not a promissory estoppel or something, some check or something.
No.
This is the
Regulation.
regulation.
Let's try to understand regulation 4 in the context of what has emerged. Now, it says that the enabling provision has been provided whereby the government of His Highness may also naturalize such persons, including wife and minor children. And Lordship wants to take a view that had it been the intention of the authority to extend it to further, it could have. And look, it does not limit also. No?
I don't
It
know.
only mentions
But it
that.
specifies. Specifying is circumscribing. Specifying is limiting.
Look, therefore, my lord, that means that minor son, daughter, nobody will get anything.
No, they will get even.
No. If he has made an application, he gets. Minor
No,
children,
No, the minor son,
minor son, grandson will not get.
Grandson, no.
grandson.
Grandson will not.
So, look, that grandson will not get.
It was whether he should get or not, that's a different argument. The literal reading of this,
No, my lord.
certificate होना पड़ेगा पहले। या फिर certificate of neutralization, then only.
आपको the
No,
difficulty is
let me
this.
put it in
Sir,
another way.
difficulty is this. You don't have these, these respondents, they don't have their grandfather or say father did not have a certificate of, did not, their names were not there in the certificate of, what is that called? Sikkim subject, SSR, Sikkim Subjects Register. So nothing is there. How can it be said with certainty that they had applied? Their ancestors as government servant had applied.
Because we have COIs. That's it, we have explained.
You have COI for many other things. If you have land in the rural area, you have a COI.
As per the regulation, my grandfather and father, they had the COI. Well, we explained, he's trying to para two of the.
They don't deny COI to any, they would give COI to all such persons within first 5 categories. But so far as employment is concerned, because you claim it only by virtue of your being grandson of a government servant at that point of
Yes,
time.
yes.
Correct. So we read it differently.
Whether that classification is permissible. That's the issue.
बड़ा मुश्किल है हम we are not finding you can
No, my lord. Let me articulate my argument, my lord. Let us not overlap everything. My first submission is very simple, my lord. The regulation of 1961 provided a provision whereby,
will make a note.
yes, the regulation of 1961 did provide for citizenship or Sikkim subject status, one who has served the government of the Sikkim for a period prescribed in the regulation.
Correct.
My father, our grandfather did serve, therefore they were issued the COI. And with the help of that COI, they were construed to be as at par with the person whose name appear in the Sikkim subject register.
Well, you have to requalify your argument. Now, that you would be naturalized,
Yes.
and it is only thereafter that your name would enter into the Sikkim subject register. It is not the other way around.
We were, our father and grandfather were issued COI.
No, it is certificate of dissemination because it says not COI, 1961. If you go,
It's not COI, sir.
not COI, it is a certificate on application after taking out a certificate.
Serialization.
Ah.
In terms of the regulation.
Regulation. So your right flows from there. Then only other COI and everything will follow.
That COI was, non-existent that time. It was a recognition of naturalization of a government servant. Finished. Now, naturalization of government servant came with certain additional benefits. Your wife, your children. And only after this naturalization process is over, which is under the stamp of, under the seal of the king, then your name finds mention in the Sikkim register. Finished.
No, therefore, whether our name.
They have gone beyond if your
From
name,
whom you are claiming?
they have gone beyond. Your name is not there in the register for some reason or the other. Still, they are trying to find out whether you are entitled for it.
It is for, therefore, it is for employment. Perhaps the Chogyal would have thought that if the father is good, has rendered meritorious service, the son also would render. Therefore, he would have thought of.
The instruction is.
He would not have thought that as a government servant with me, with Chogyal, his son would be interested in business.
That grandfather, that the government servants. Government servants them.
नहीं है कोई नहीं आया था कहाँ है इसको तो दिया है उतना ही बहुत
Only in 81 COI was issued.
But that is a much later thing. That's
No,
a
no,
later. Tell me one thing.
The instruction is very clear.
Tell me one thing. Now, if your grandfather's name would have been in the Sikkim subjects register,
Then this is
finished. So therefore, 18,000 of you,
only
Just-
class one.
18,000 of you
You say, I mean, a window has been given to you. And not that that window is just on, for the, only for, on papers. 43,000 have been included.
74.
74,000 have been included.
18 still pending.
18 still pending. You are one of the 18,000.
Yes.
Now pursue it. Pursue it. We are not asking you to do anything. I mean, this is how we understand, because we go by, when you talk of, what is that called? That which act? General Clauses Act. Concluded transactions shall be saved. Then we get back to 61. 61, your grandfather, according to you, your grandfather was a government servant. Whether the evidence of his having been naturalized, on his having filed an application, not all government servants would have accepted this naturalization. So whether your grandfather had filed an application pursuant to which the Chogyal gave him that naturalization rights, that is under question. How will it be proved?
But there is a record of the persons who served the Sogal during that period.
But did you make an,
Based on that record,
did you make an,
COI is 1981.
did you make an application? Did your grandfather make an application? This fact can be questioned and seen only when you produce evidence. Now, why do you want to bypass every such thing and want to have COI only on the basis of dissent of a government servant who, for all you know, not all government servants, not all employees under the Chogyal were naturalized?
No.
No. So only those who wanted, and the government thought, and the king thought that, well, he deserves, he has helped us. कैसे, how will it be traced? कहाँ से देखेंगे? How do you say it is concluded?
No, we don't say concluded, we say right accrued to us.
कैसे? Who are you?
For a consideration. That my grandfather served
Well,
the Sogal.
does it say that all government servants, all persons working under the king, they are naturalized? Do they say that?
No.
No. So
One has to
therefore,
apply.
huh?
One has
They have to apply. So you have to bring evidence. Go before that committee is there. It'll see. Because your name wrongly. Why was it wrongly not mentioned? Otherwise, if you're naturalized, it will be there.
Well, definitely there is an aspect which has arisen during the course of the discourse, my lord. That is a fact. But here basically what we are trying to say is what you envisaged in 1981, why you
Are
reneging?
reneging.
In the subsequent notifications.
But your argument
No.
on the General Clauses Act, then you will not.
No,
that will
that is an argument.
No,
which
so
is-
naturally
which is-
this argument also we take into account, because
Yes.
this is an important argument.
Yes.
But this argument, fails when we read section 8(4).
My lord, that is an aspect, my lord, I would respectfully submit. Lordship will not decide that in, my lord, a situation where the pleadings are not there. That was not the question posed.
Don't press this point.
No, it was, no, that's what kindly
Because
appreciate.
for a point, see, whenever you talk of 1961 regulation, your right accrues from there,
Yes,
because not all government servants were naturalized. So your grandfather, according to you, was naturalized. Now there has to be a certification. Certification is not there wrongly or rightly. Then it has to be proved. There is a committee which is looking at it. Now that only would have given the right as a matter of course, because having taken birth in that family.
we have been able to establish, that is why COI was issued to us on that category.
COI may have been issued to you by virtue of your having purchased a property.
No.
May have said.
Only on this ground.
Hmm.
Otherwise, my lord, they are very strict.
The word COI has come from 1976.
Yes.
Look at this. It's only for employment. Look at that. Come to 76. If there is any notification from 76 to 2010, which does not, the baseline is not employment, well, we will recalibrate our thinking.
Lord, in order to ascertain the residential qualification of candidates who claim themselves to be local at the time of seeking employment.
But wahi na hai. That is the catchword.
it has been decided that candidates should be asked to mention whether their parents' name have been recorded on or before 15/5/75 in the relevant government register. Relevant government register could be below employment register, it could be land revenue record.
Relevant government
It could
register
be
is.
Sikkim subject
Who
register.
there, no, who stops you? This is Sikkim subject register.
Yes.
Sikkim subject register is the register maintained of citizens. It is not other relevant government register. Suppose.
Then let us put it this way, Milord.
No.
If-
One
no.
second. You have, I mean, that you have a ration card doesn't mean that you must be having a passport also.
Correct.
We must distinguish that.
Yes, yes.
Yes. So therefore, this old Sikkimese subject register is part of the rules of 1961. Under the regulation, rules were framed in the same year. Rules are also repealed. The regulation was nothing, rules, same thing. In the rules, they have a provision that they will maintain a Sikkim subject register, which only denotes not your property. It
Yes.
only denotes your being local citizen. You being one part of it, that you have not taken birth there, you don't have property there, you are not living for generations there, because you have rendered service and you have asked for it. The king is happy, he gives you that naturalization along with your wife and children. Therefore, when they are talking of relevant government register, they are talking of old Sikkimese subject register, which was required to be updated. The other government registers are maintained by the departments. Suppose you want to purchase land, this Sikkim register also would be one of the evidentiary value, would be of evidentiary value, plus another thing. So this
When
CO
they say.
where
relevant-
COI started in 1976, 76.
CY never started in 76.
The identification for the purpose of employment,
identity
and it
process-
was the rubric of certificate of identification was given.
In fact, two attempts were made, one through this mode and another in Milord when these 73 odd persons were included, that was in 89. These are the two category of people. Now, Milord, when somebody.
Anyway, let us not get into that argument. How do you get over this number 4?
No, Milord, I know.
You are from Sikkim. You are one of the respondents. Huh? You're according to the present status, you are a non-Sikkimese local. Where do you hail from? Now that you're Sikkim, you want. But your grandfather was from where? Which place? Why his name was not there in the register? So therefore, you are one of the applicants there before the committee. No, you are one of the applicants before the committee to have your name entered in the Sikkim subject register, like other 74,000 people. Pursue there.
Milord, I was also trying to.
We are trying to find out some way of vindicating your rights, but we are not getting one now
No,
present.
Let
We are
us-
making
let
efforts.
us make one more attempt, Milord. Let us take an example. Now, Milord, we say we have a right. Our right has not been determined.
It's just Now, Mr. Chaudhary, we were only deliberating amongst ourselves. your ground is, if we can call it a strong ground or a weak ground or ground to be considered, is that till some time, till 1981, till the time these insertions were made, that it is for employment purposes, for employment and no other purposes, till such time, whatever was the certificate of identification, that was used for other purposes. That's your,
They're
yeah,
local. That is the reason.
as a local. That is, yeah, that is your biggest, plank on which you can stand and raise your arguments. उसके अलावा कुछ दिख नहीं रहा हमको.
Can I put it in?
Did you follow what
Yes,
we
yes,
said? I said your projection line is this, that prior to 1981, prior to the insertions in the notification, you were utilizing that certificate of identification. You were getting a certificate of
With the help of
identification
that,
and you were utilizing it for all purposes. Not by virtue of any other qualification in 1 to 4, but because of your being a descendant, you're being coming
Government
from a
servant.
family of a government servant. Correct, well, that can lead you to some.
My lord, can I put it in another way? My lord, what we have challenged, few notifications issued from time to time. Now, my lord, the position which was obtaining in 1981 is sought to be, my lord, disturbed by the subsequent notifications. Now, if these notifications would not have been issued, our positions would not have altered, it would have remained intact. We would have continued to enjoy the benefit.
You will not be able to make any argument in NRC.
No, Lord, what I'm submitting is, now what are these notifications? These are all executive instructions. That is my, in the written argument also, we have taken this, my lord.
Right. Right, पटेल ने किया है. It is उसको limit किया कि हम been a
Is it possible, my lord, that the claim which we are making before lordships, that authority should consider?
They are considering, no? Committee is there.
No, now till now they have not done it.
No, the committee is there. You pursue that.
No, Lord, my humble.
We have been called upon to decide whether the judgment passed by a single judge is correct.
Yes.
Now, we can, if you don't press this appeal, we will say that.
The state's appeal is not our appeal.
You state appeal. If,
No, Lord,
state
litigation will take a lot of time, my lord. What will happen to the students, the children of ours?
So therefore, you should.
No, Lord, what I was thinking is, my lord, by what statutory?
In fact, the
our
learned.
rights have been
In
terminated?
fact, I mean, everybody becomes wise in the hindsight. So today we have a feeling that single judge, when the matter was heard, I think it was at that time only. She should have directed the authorities, or should have said that it is expected that this inquiry should be completed, and whoever is entitled for being called a security should get it finished. Not to get into Article 14, 15, 16. That would have saved 15. That would have saved 15 years.
Well, all that I'm trying to submit therefore is, now these executive instructions which are infringing our rights, whether it could have, it boils down to that, my lord. Because the substantive right which we have to a consideration, that is yet to be done. The substantive right of consideration, my lord, that is not emanated.
Where from did it come? I am not understanding how did you get that right? Only because it was being used. In whose case was it being used? We don't know. Suppose some functionary of the excise department, I mean, forget about excise, some functionary of, say, I mean, suppose RERA, Real Estate Regulatory Authority. It has its own, tick boxes. Now, some certificate was wrongly used as a substitute for other tick box. Now, can it be said that the right flowed?
Lordship will kindly consider one aspect of the matter, which competent statutory authority has decided on our right.
No. You did not
So
have.
by issuing.
They are arguing that you did not have a right to be called a Sikkimis.
No, we are not calling that we should be treated as a Sikkim subject.
Then
All that we are saying is, my lord.
But nahi ho sakta na, because Sikkimis, then you again fall back in that quagmire of 371F and section 4, subclause 4 of the establishment rules of 1974. It's a no-win situation.
That is co-employment.
It is.
That position we
So
accept.
therefore, the COI, they say that it is.
Very similar,
it
in
is
spite of.
Your case is, though it was for employment purpose, for all other purposes, we
You are
have been
getting
given the
benefit.
benefit,
Yes,
but by
yes.
virtue of so and so,
These
so and so.
notifications, we are not
So,
getting.
and this is by an executive
Yes.
head, it could not,
You-
our right could not have been
Yes,
taken.
Now, let me put it differently. Now, I think we have argued more than what is required. Now, we will conclude this. Suppose you had, just a minute, let me come to that 4, which is that page.
No.
96.
Five.
96.
Come to page 195.
6.
Come to 195.
One.
Let us have the 1995 notification first.
Yes.
Now, you're not a person whose name is, your name is not recorded in Old Sikkimi subject. Correct? Yeah, hat gaya.
Our name is in 5 minutes.
No, just a minute. Don't come to 5 now.
Okay.
Do you, or have you established beyond doubt that your name, your father, husband, paternal grandfather, brother has been recorded in Old Sikkimi subject? Aapka koi bhai?
No.
Nothing. This also goes. Then number 3, person who has had agricultural land in rural areas and has been ordinarily residing. Do you come in this category or not?
Though incidentally, some of us has land. below, but we don't
Then
count.
you need not go to 5. If you have land in the area, then because this is not.
After 81 registrations. we
Sir,
are-
please, now if you qualify under 3, then you need not even go to 5.
Yes.
If you qualify under 3, you will be all right. You will be given the certificate of identity.
Group covered by 5.
Covered by 5. Therefore, you are exclusive group. And for you, this certificate is only for one purpose and not for other purposes. If you fail in any one of the categories, and suppose they would have said that for any certificate of identification, they must have all of these except 5. It would have been very difficult. Just a
Can you
minute.
come to 4?
A person who is holder of Indian citizens by district collector, government of Sikkim under so and so
It's
as
an
a.
insertion.
Because there is an enumeration, that 80,000. This is added for this 80,000, pursuant to
I
that
know that.
proviso.
I know these are the 89 means enumeration.
By whichever window we are trying to access,
So, look,
that gets closed now.
the purpose, my purpose of referring to
Up
four was to
now
show
for other
that
benefit.
these are the person maybe similarly situated like us.
Now suppose similarly situated is something different. Two persons different. Classification Article 14 Edmund Buck. The argument will go to I don't know which level.
Let us
Now
not
suppose do you have land in the agriculture in the rural area? और land है तो फिर इनको जरूरत क्या है number 5?
Some of the
Why do they need number 5? They come in number 3. एक चीज थोड़ी है. There are many things.
they say some land transfers were permitted post 81 notification.
What was done? What was not done?
95 में तो 80 में तो cover कर ले.
And they not, in some cases it has so happened, supposing the father bought the land, now they cannot transfer it. Because they do not have COI.
क्या करेंगे फिर उसको? That you will have to pursue it.
At the end of the day, Milord, with all sense of responsibility, I am making this submission. In the background, now can this executive instruction determine our fate?
The difficulty is that if you vindicate your right, we will say that it
But
could
what
not be
we
taken.
challenged before the learned single judge was
that
this
case-
notification.
No, in that case, we will look back to 1961 and find out, and we'll say that you did not have a right in first instance. Where has it been taken away? Who are you? So far as Sikkimese subject is concerned, who are you?
Say that under 61
That is
regulation,
your right.
we don't have a right is not wrong, not
No.
correct. For the simple reason, they themselves has incorporated in 5 for the purpose of employment.
Therefore, you can't have both. No,
I got a question. of
only
both.
day before yesterday, Mr.
In that
Chaudhary.
case, my lord, in
Chaudhary,
that case, state would be blowing
this
hot
is
and
the-
cold.
this
On
is-
one hand, they'll say
Mr.
we have no
Chaudhary,
right, but for the purpose of employment.
Just a minute, Mr.
Employment.
Chaudhary, this is the difficulty when a senior advocate like you keeps educating the benches. No, you have not heard me. I'm saying it in your praise. You day before yesterday, you argued about approbating and reprobating at the same time. Correct. So we are, that concept is very fresh in our mind. Of course, we knew it, but then can you be allowed to approbate and reprobate at the same time? You say that everything flows from my 1961 regulation, concluded transactions saved under the
Yes,
General Clauses
that-
Act.
that
And then
is
you
still
say,
maintained.
and then you say that when you don't fall in that category, you're not the you're not the son of minor.
But I was only trying to test the
So
state's
therefore-
argument.
Therefore, if that
When
is
they
the basis.
say, when they say that it is only for employment. But the
Show us-
fact of the matter is
Show us,
employment.
Mr. Chaudhary, show us a way whereby we can expedite your being considered for being added in the Sikkim subject register. Show us the way. Now,
Lord, only way perhaps would be to refer to process those pending applications. Lord.
we will make a request.
Or my lord, my lord will, armed with your lordship's order, will apply again.
That we
It's not
can't.
a question of being.
No, that we can't.
Other
Whatever application you have to make, you have made. Yours is pending. No, we will not do all that. We will only make a request that the committee is still functional, it's still existing. They have done it in the past. Thrice they sat, they cleared how many? 74 or 43? 74. Now let them also decide. And that committee sits where? Mr. Day?
My lord, is this Ministry of my lord, Home Affairs thing. It
Ministry
sits
of
at
Home
Delhi.
Affairs. Don't exert your pressure before the Ministry of Home Affairs not to include them. You keep
My
aside.
lord, we are,
You keep aside and don't trouble them.
we are a non-player, my
My
lord.
lord has given
We are a
us-
non-player. The district magistrate is only a functus officio. That's
My
all.
lord,
more.
regarding this final summing up, my lord, regarding reference of the case to the committee, my lord, would your lordship just one last opportunity? Let us have.
अब
Because
बहुत दिन हो गया।
this is a matter. These are.
You can't.
I'm.
Mr. Chaudhary, this is you, nobody else.
I know. I'm obliged for that.
Nobody else could have improved upon this argument as much as you have done. Now there is nothing. We say, we acknowledge it.
All that I'm trying to submit is, my lord,
We-
he alone is not in a position to give that.
No, we will, then let him not
Or
give.
tomorrow, my lord, tomorrow at 2 o'clock, my lord, we'll just give that information.
Tomorrow.
Tomorrow
We keep it for
Only
just,
for this, only,
we
no,
keep-
no argument, no nothing.
okay, we keep it for judgment tomorrow.
Okay. Meanwhile, well, I'll have that instruction.
Because we want to, I mean, no work pending before the court closes. We will work for whole of the night, if possible, and then keep that open.
Miller,
We'll keep it at 2.
2 o'clock.
2 o'clock, but we say that arguments heard,
Yes,
we post for judgment.
yes. Deep problem.
But you have argued, no difficulty. We were made to think. But difficulty is that all windows were found to be closed by us.
But settled with such a repetition, my lord, only Mr. Chaudhary can make out a case. I will humbly say that. If it
Mr. Day, these observations from the bench have made you happy, therefore you're praising him. Otherwise, you would not have. Arguments heard. Yes, sir. Arguments heard.
My lord, my learned additional advocate general appears with me, my lord, Mr. Valla.
He will?
Mr. Valla, additional advocate general. My lord, will, in our comment.
Everybody's appearance, your appearance also. She has been moving up and down and asking for all the information. All, and the lady is standing by her side. Sabka naam dijiye. We have heard so and so. Post for judgment at 2 p.m.
I seek your lordship's leave to join online tomorrow, my lords. I'm in some personal.
Doesn't matter.
Physically, I'll not be here.
Sure.
So, my lord, it's my duty to be here when your judgment is.
No.
announced.
We will, this is for the purposes of concluding the act.
Yes.
We'll tell you what we have decided to do, and then that judgment will come after 5 hours, maybe tomorrow, maybe next day. Correct? All right, thank you.
Deeply.
Just tell us, show us that way.
Yes.
We will
Tomorrow.
tomorrow. And do that in the morning. Do that in the morning, not necessary for them to come. You
Okay,
do that in the
at
morning so that
10:30, I'll confirm.
10:30 you come and
Yes.
tell us.
Only I remind myself, my lord, the exercise is to be done not by the writ appellants, but by the central government, who incidentally is not a party before your lordship.
No,
My lord, I don't make an exception or objection to it.
No, no.
But it's my duty.
See, look,
to
look at this. I mean, we will consider this aspect of the matter, that the applications are pending before the authority, before the committee. So let us see. That doesn't deter you. You have only done it. No members of parliament have said that. From Sikkim. You should not have any objection.
No, we absolutely don't have, my lord. My lord.
Otherwise, it will appear to be a vindictive action. You want to keep away these
absolutely
people.
not. My lord.
So therefore, if the committee is
These
sitting
are the
collect-
citizens of India staying in Sikkim. These are citizens of India staying in Sikkim. They are voters, my lord.
They are
They are
voters, so
citizens.
allow them to purchase land.
My lord, for that they
Allow
have
them to purchase land, sans the COI. Allow them to sell their lands.
For that-
At least allow them to sell their land so that they can go and settle in other parts of the country.
My lord, it's a very interesting subject. Incidentally, my lord, I was given a copy. This is a law.
No, we are only asking you that you don't want to give them employment, let you not, because of these rules. But then allow them to at least, I mean, if you want them to, they are Indian citizens, settle there. So if they want to purchase property, they can. If they want to sell, purchase, of course, there are certain restrictions. For sale, for changing the demographic
For
component,
sale also there is restriction.
change of demographic situation, you may adopt certain rules. But then if they want to sell property, why do you stop them?
My lord, like in Meghalaya, I cannot sell my property to anyone I like.